the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated. Welcome everyone to the Fourth Circuit this morning. It's good to have you here, and we look forward to the arguments in these four cases, and particularly in the first case, Neal versus the East Carolina University. Mr. Barfield.
Please, court. Your Honors, this case, prior to the onset and the exhibition of symptoms of mental illness.
You can take your mask off there if you want.
Prior to the onset.
I can hear you better.
Yeah.
Prior to the onset of her mental illness symptoms in spring of 2015, Olivia Neal was going to graduate from ECU's master's program. She was going to get her MSW degree. All of the things that were said about her by ECU when she was dismissed regarding what may have happened in 2013, what may have happened in 2014, none of those things as of February 10th, 2015, were going to keep her from graduating and getting her degree.
So why do you say that?
Well, Judge, what we know is that despite in, say, the fall of 2014, there having been some issues, which I think are under contest in exactly what happened in 2014. But when we were done at the end of 2014, that grade of A that's given in the field course is not just an academic. One of the things that ECU emphasizes is that, well, grades are not everything. We have a professionalism component to our program, and that's right. The thing about the grades, though, in this case, are that the grade specifically incorporates that professionalism component. That grade primarily is derived from the learning agreement, and we know that the learning agreement has two specific areas in which the student is measured, with specifically with respect to professionalism, carrying oneself as a professional, acting professional in dealing with clients, with other professionals, and so forth in your field practice. We know that in 2014, she was graded at the highest 4 and 5 levels on those measures of professionalism. So the grade in this case at the end of 2014 really means more than it might mean in some other professionalism cases where the grading is separated out. You get an academic grade here, but we're assessing you professionally over here. In this case, that assessment of professionalism is part of that grade. And that
right. So that's part of the field work, but not necessarily part of the rest of the curriculum or learning experience.
That grade of A that you get at the end of the term on that field seminar, which includes the field practice, is a combination of your clinical grading and your academic grading. That's correct.
Moving forward to 2015, though, didn't she admit to several instances of unprofessional conduct in February of 2015?
Certainly did. And there's no question that.
And so if professionalism is a component of continuing in the program, which I think I heard you say professionalism is a component of it, why isn't that enough for the university to have dismissed her from the program?
Because in this particular case, this particular incident or this period of about 2 to 3 weeks was a transitory condition, recognizing that.
Didn't she assault her sister in 2013 or 2014?
Did not. She was charged, but the record would show that that case was dismissed. So the conduct in 2015 was apart and separate from anything that they've ever alleged occurred in 2013 or 2014. Moreover, up until.
So why do you say that? I mean, you have these continuing instances over several years of aberrant behavior. Well, why do you say it's different in 2015? I mean, the degree might be different, but it seems like the character of the acts is somewhat similar through the years.
Well, in this particular case, I think that there is a different character in the acts in the sense that in 2015, these are clearly recognized by the faculty and then later diagnosed, specifically manic behaviors secondary to a specific disease, bipolar disease. That's not true with anything that was alleged with regard to 2014, 2013 before. And in this particular case, I think the most important issue we address here for summary judgment purposes is this. The most important factors, in fact, the factors that the faculty describes both in their affidavits and in the notice of dismissal, the most important factors that they relied upon to determine that she didn't meet the professionalism component were A, she missed too many classes and supervisions, and B, she was impaired in such a fashion so that they could predict that her interactions with others in the field in clinical practice was going to be impaired in the future. And
Was going to be unprofessional because she had behaved unprofessionally with several of the professors and others, and she conceded that, right?
correct. But in this case, the evidence is also there that this was a condition that was treatable and was treatable. ECU's faculty has acknowledged in their affidavits that a treatable mental health condition that may have caused a transitory or temporary conduct problem is not by itself grounds for dismissal. They say, well, we actually allow people to graduate with these kinds of issues before as long as they're treatable. The code of social work, the code of ethics for social work specifically addresses that. It says, if you should become impaired because of a mental illness issue, then what you do is you step back, you seek treatment.
When was it that she told them she had a mental illness?
Well, she didn't tell them until she came back with the note from the doctor.
Until after they had terminated her from the program, correct?
That's correct, but the termination wasn't final. So at this point, they certainly could have.
But the university was not made aware by her that she had a mental illness or any need for any accommodation for that disability prior to her termination from the program, correct?
Correct, but again, we don't contend that she was disabled because it's a temporary condition, not a persistent disabling condition. She didn't need an accommodation. She needed to be treated like any other student who had a temporary physical or mental condition. And the deposition or the affidavit of Professor Carpenter Abbe said, well, that's right. It's the usual practice of this program that if you missed some classes, if you had to make up some work, you'd be allowed to do so. The point here in it not being final is that the ECU appeals policy specifically says that this dismissal from the program was not to become effective until the appeal was resolved. She had a right to continue in the program under their policy through the rest of the semester, or at least until the appeal was heard. So
we're here on summary judgment. Can you just succinctly tell us, what do you say are the factual disputes that barred summary judgment?
There are two essential ones, Your Honor. The first one is, did she miss any classes or in excessive classes? All of their affidavits, their notice, all of it relies upon and says it's actually dispositive that she missed too many classes to graduate, that she missed too many classes to make up the work, when in fact the record is clear that she had absolutely one absence in the entire semester up to the time of her dismissal.
So what about the stipulation on page 893 of the appendix? Plaintiff failed to attend Dr. Yoon's class with no notification. Plaintiff also failed to attend Dr. Carawan's field class seminar with no notice. And you stipulated to that.
And that was on March 3rd while she was in the hospital, and that is the only class that she missed. The other two classes that they reference, they keep saying she missed too many classes, but the other two classes were never held. Those classes were on February 17th and February 24th. No classes were held on February 17th. No classes were held on February 24th. So that's the fact. They're depending upon a contention in their own notice and in their own declarations that she missed all these classes and she missed too many classes. But in fact, she missed one. Dr. Yoon's syllabus says you can miss one, no penalty. There's no penalty for one. If it was it would be excused. Well, she was in the hospital. Dr. Yoon's class says if you miss three, you get an F. But again, she didn't miss three. She missed one. And that's a huge factual dispute in this case. And one, frankly, which the evidence is all in favor of the plaintiff. The second factual issue, very important, is the contention that she missed field supervisions. Likewise, the record is clear. She didn't miss any field supervisions until she was in the hospital. If you go through the email record from February 10th all the way through the time of her dismissal on March the 17th, there is no reference in any of the many emails that she failed to attend or show up for a field supervision, not once. There are references to field supervisions again being canceled because of weather. There are references to her asking for field supervisions to be set, but again, because of things out of her control, they weren't held. But on the factual record, the faculty themselves say the most important thing after too many classes were missed is you didn't have field supervision. Well, the record just simply doesn't support that. The record supports that she did have field supervision, again, until she was hospitalized. And again, up until the time they realized she was hospitalized, they weren't actually talking about dismissing her. They were talking about what we can do to help her because she has this temporary mental health crisis. And when it's said that she didn't tell them that she was suffering from mental illness, the record is replete with
If I could just go back, what about her testimony? The question was, did you also miss any classes in the fall of 2014? It's possible. How does that create a factual dispute?
Well, it doesn't as to 2014. In 2014, she certainly didn't miss any significant number of classes. She got an A in both of them. So obviously, whatever the record would show for 2014, it was nothing significant about missing classes. The missing classes issue really only comes up. In fact, even when they had the ARC meeting in 2014, if you read the emails leading up to that, they don't reference her missing classes. There's a lot of things that they reference, but not missing classes. So the bottom line is that the missing classes issue only arises in 2015, and the factual record supports the plaintiff's position that she missed one. But the record also supports the factual position on the plaintiff's side that she didn't miss field supervisions of her own accord. Most importantly, they also relied upon and said, well, you weren't attending your field. Well, that's just simply false. Again, the factual issue in the case favors the plaintiff. The records from the House of Fordham show she was attending her field placement. All of the evidence from the people who supervised her at the House of Fordham is to the effect that she never missed any of it except when she was hospitalized. All of the record from the House of Fordham is to the effect that she was exemplary in all of her interactions with all of the clients and other professions. In other words, as a factual issue in the case, the ECU's position is, well, we rely on the idea that you're certainly going to interact badly with clients and other professionals. And we say that already started by the time that we dismissed it. But in fact, the record is that hadn't started. It never happened. And there's no evidence anywhere in the record from 14 or 15 of any improper, inappropriate actions or activities in her field clinical work. So those are two things that they relied upon heavily. Absences from class, record doesn't support it. Didn't go to field supervision, record doesn't support it. Are in our minds certainly going to be having inappropriate interactions with your field placement. Record doesn't support it. The record supports the opposite conclusion. In fact, in this case,
what about our opinion in Halpern where we said that the law does not require the school to ignore misconduct that has occurred because the student subsequently asserts it was the result of a disability? That sounds like the argument you're making now. The misconduct should be excused because it was the result of a transitory mental illness.
We're not arguing that the conduct should be ignored. We're arguing that in this particular case, because there are disputes of fact of which they relied upon. They didn't just rely upon the incidents on February 10th or 24th and 25th. That's not the things that they relied upon. Their record and reasoning was much larger. We don't say that they should ignore those things. We say that this case is different from basically virtually every other professional school case, in that, number one, there is a dispute of very material facts that they contend are material. If you look at Halpern, there was no issue, no disputed facts in that case. Halpern was a persistent course of conduct over many years. He failed courses. She never did. In Halpern's case, it's clear that his conduct was willful. That is, the conduct that was specifically at issue in that case was willful conduct. Here, when we talk about the conduct for mental illness, it's clearly not willful conduct. And most importantly, it's transitory. And that's what I think makes it different.
I'm still not quite sure why you say it's transitory, because when you look back at what happened, she withdrew from school in the spring of 2013. She was readmitted in the fall of 2014, even though there was a policy that you had to start over. They let her go in with credit for her first semester. So that gave her a second chance. And then shortly after the semester began, they had one of these A&R committees because of the difficulty she was having. She made agreements to improve her conduct. So they gave her a third chance. And then we come into early 2015, and it seems like now what you want is a fourth chance.
Well, the point I would make about that argument goes to the issue of whether there's to be given deference. We don't have the case. I didn't find the case. I don't know that the case is there. Do they get deference if they specifically rely in exercising their judgment on facts that aren't true? This is the issue we have here. Are they entitled to the deference that we gave in Halpern, when in Halpern we all agree on what the facts were? Here we have very important to them facts they said were most important that were wrong. What deference is to be accorded to that determination when it's based on misstatement of the actual underlying relevant facts? And I think that's what's most important here. Those facts are really in dispute, and the faculty said that those are the facts that matter.
Thank you, Mr. Barfield. Ms. Totten?
May it please the court. My name is Vanessa Totten, and I am from the North Carolina Department of Justice. I represent the appellee, East Carolina University, in this matter. ECU respectfully requests that this court affirm the District Court September 28, 2020 order granting summary judgment on appellant Olivia Neal's disability discrimination claim under the Americans with Disability Act. Neal was a graduate student of the East School of Social Work Master's Program, who was dismissed in spring 2015 for failure to meet the program requirements. During her enrollment, Neal engaged in a pattern of misconduct that created an environment that was disruptive to the university, faculty, staff, and students. The district court order should be affirmed for 3 reasons. The first reason, the undisputed and stipulated pattern of misconduct negates Neal's ADA claim. 2, the district court's order, which relied heavily on the Neal stipulated facts, properly determined that there is no general issue of material facts. And 3.
Now, Mr. Barfield specified 2, he says, material facts in dispute. How do you deal with those?
The two particular ones that he mentioned was her attendance. The first thing, she stipulated to her that she missed classes, in which your Honor.
Classes plural or a single class? I'm sorry.
So she missed multiple classes that she stipulated to. She also what she did.
Well, and Mr. Barfield says she missed 1 class.
And the record, it actually shows that she missed the required number of field supervisions for a time period where she was not attending her required field placement. That's stipulated on the Joint Appendix 893 at section 107, 894, as well as section 113 through 114. She also missed classes, as your honors pointed out, with Dr. Yu and with Dr. Holloway, which was on pages 100, as far as there's emails about this too, which was 183 through 184, and 187 through, 1183 through 1184, and then also 1187 through 1188, which were some of the classes that she missed. She also missed assignments, which she does not dispute as well.
Well, I'm talking about the two specific disputes that he identified. You're saying they don't exist, correct?
She stipulated to,
So there is a dispute between parties that disputes the fact or what trials are made of,
so there isn't a dispute.
unless they're immaterial.
They're immaterial in the sense that she stipulated to majority of the,
So you saying that she stipulated that he's simply wrong in telling us there are disputes of fact.
so there is no disputes of facts because she stipulated. And the way, as far as, let me step back. So in the Harper case, it says that misconduct, even misconduct related to a disability, is not itself a disability. It may be a basis for dismissal. In this particular case, she stipulated to the fact that in the Joint Appendix, which is located on 875 through 913, that she did miss classes. Whether-
Classes, plural, or one class? I only see a stipulation for one class, and that's at paragraph 108 on JA 893. Is there another class she stipulated she missed other than Dr. Yoon's March 3rd class?
So she also stipulated that she missed, but as I mentioned earlier, the field supervision, which was part of her coursework, and that she was not attending her field placement, which I
Which
mentioned earlier.
which paragraphs are those?
So that is Joint Appendix 893, Section 107, Joint Appendix 894, sections 113 through 14. And she also, Neil submitted an affidavit in this particular case from Lynn Tyndall, who was from the House of Fordham, which admits in her declaration
Okay.
that in spring 2015, Neil went missing and was not responding to communication. And that was in her own declaration, which is on the Joint Appendix on 2,641, section 15 of her joint, and her actual.
So what was your, after the reference to 893, paragraph 107, which is the field visit on March the 3rd, what was the second reference? I just didn't get.
There was other stipulated facts on 894, sections 113 through 114. And those were also included.
Right.
And then she also submitted her affidavit as well.
So 114 is from February 12th to March 16th. She should have had at least 4 supervisory sessions, and she had none.
Yes, Your Honor. and she
Okay.
Stipulated to that.
Mm-hmm.
And then again, her own declaration from Lynn Tyndall said that she was not showing up to field placement on Joint Appendix.
And were those facts, so none of that was disputed, you're saying? You say there are no disputes of fact? Or if there are, you gave her the benefit of them, right? You had to,
Yes,
for summary judgment.
she did, but she also, the court gave the benefit,
Right, the court had to give her the benefit of the facts
Yes, Your Honor.
in dealing with the summary judgment motion.
A majority of the summary judgment order, as you will notice, he actually cited to her stipulations. So
Mhm.
this is what she stipulated to. And as far as Linda Tyndall, when that was cited, that was her own declaration that she submitted in support of her case. Now, the other question, that I think that was mentioned, Your Honors, was about that she got an A. I believe that was something else that was brought up in fall 2014. That was actually after she had faculty assistance. As your honors correctly mentioned earlier, in fall 2014, she was referred to a admissions and retention committee meeting.
And that was after she was charged with assaulting her sister, correct?
Yes, if you actually look in regards to that fact, if you look in the Joint Appendix on 888 through 889, which are sections 73 through 74, this discusses where she was referred to the ECU Office of Student Rights and Responsibilities after she was after she was arrested for an altercation involving her sister. And as a result of that incident, she was required to submit a counseling verification form, which was separate and apart from the actual any criminal proceeding, and she stipulated to that. Is that
So you're not disputing that generally she made good grades academically?
with faculty assistance in regards to,
But you're not saying that, she was making, there's no allegation that she made D's and that's why she was discharged.
so I'm in regards to the fall, to answer your question, Your Honor, in regards to the fall 2014, she was missing assignments, she was not coming to class. When she was referred to the first admission and retention committee meeting, because she said that she would correct her behavior, the faculty with their
Yeah, but even if all that's accurate for that, isn't it fair to say generally, except for the time she was AWOL or however you want to characterize it, she generally had good academic grades?
I would,
That's not a trick question.
yeah, and in
Yeah, I
terms of
mean,
the
yeah.
facts, based on the facts and the stipulations, she, her grades were generally good. But with that said, Your Honor,
What was a 3.94 was her grade point average when she was terminated from the program, correct?
I'm-
I know these other grades didn't count, the last two grades, but
yeah, I know that at the end of the semester, there were some incompletes at that time period.
But she had a
But
terrific,
before
she was a
that-
good student.
She was a fairly good student.
She was a
yes.
very good student.
yeah,
And
there's no
faculty
reason.
assistants, you're talking about something wrong with students getting faculty. I thought that's what the faculty was there for. They're there to give faculty, student assistance.
But I would like to point out, in her stipulation, she says, she stipulates a student's academic performance is not judged solely on grades, but their professionalism. That is in the Joint Appendix at 881, sections 33 and 45. With that said, this court in Sheen versus University of Maryland Medical Systems Corporations, it said one may achieve high marks throughout one's education and still not be able to perform the essential functions of her job. And in that case, the physician that was dismissed actually did have high marks, but he did not meet the professionalism requirement. He also turned in late submissions of assignments, had poor judgment, and the faculty had to essentially assist him as well in his classwork, which is similar to the facts in this case. In that case, they actually upheld the dismissal. I think the context in this case is very important. Neil was a graduate student to become a healthcare provider. As a clinical social worker who will be responsible for serving a vulnerable population, often facing life and death situations, and who are at risk of harming themselves and others. Now, Neil stipulates master's program students must exhibit professional judgment and self-awareness of their own personal problems. It is expected that students act in accordance with the same ethical and professional standards applicable to the profession. Social worker clinicians must ensure the emphasis is always on the well-being, the best interest of the client, and not themselves. As a student, her ECU policies In accordance with Social Worker Code of Ethics, students must maintain a high standard of professionalism. As mentioned earlier, a student's academic performance is not judged solely on grades, but their professionalism. For instance, the Harpin case was mentioned earlier. And in this case, it said clearly, misconduct, even misconduct related to a disability, is not itself a disability and may be a basis for dismissal. Similarly, in Zomick versus Marshall University Board of Governors, which is also a Fourth Circuit case, said that in this case, the court also upheld dismissal of an ADA claim where a medical student was dismissed for unprofessional conduct. Here, as mentioned earlier, Ms. Neal actually stipulated to an overwhelming volume of misconduct. Given the time constraints, I cannot say every single misconduct, but I would just like to summarize a few. In the fall 2014, as mentioned earlier, she was referred to the first admission and retention committee meeting, which is convened when a student is not meeting the program requirements to determine whether the student will be terminated. Some of the facts leading up to that was in fall 2013, Neal stopped attending class and was distracted in field placement. In fall 2014, she was missing assignments, as mentioned earlier. It was also mentioned earlier that she was referred to the student rights and responsibility for an altercation involving her sister, where she had to submit a counseling form. She also stipulated that there was a time period in fall 2014 where she was on the phone in every class, and a professor had to warn her that her behavior was distracting other students and directed her to get off the phone. But she was given another chance. She was allowed to continue the program, but she was warned that failure to improve could result in her dismissal. Neal failed to improve her conduct and performance and continued to exhibit a pattern of misconduct, which led to a second admission and retention committee meeting being convened. Leading up to that, in addition to the prior misconduct, she had missed an assignment. When the Office of Student Rights and Responsibilities followed up about the overdue counseling form due from fall 2014, Neal left an unprofessional voicemail, and she also sent an unprofessional email. She also stipulated that she sent an unprofessional video to the faculty of her yelling at her parents. There was also confrontations with the faculty. The first one was the February 10th, 2015, where she entered her professor's office, and again, this is stipulated, and engaged in disrespectful and unprofessional conduct for over 2 hours. During this time, the professor was unable to leave the office, and Neal told him that she would stand in front of his car to prevent him from leaving the staff parking lot. Other faculty and staff had to intervene. Now, there was another incident in fall 2015 where her field instructor and professor followed up with her to check on her, and she told the professor to shut up and listen. Now, there were, as mentioned earlier, she also had missed the required number of field supervision, which is stipulated in the record, and that she also failed to attend classes and did not notify the instructors and follow up when they try to communicate with her. Now, these are just a few examples of the stipulated and undisputed facts that are, this is not a complete record. Now, argumentatively, one incident of misconduct would be sufficient for dismissal. But when you consider Neal's overwhelming pattern of misconduct, no argument can be made that her dismissal was not justified. Now, in regards to the dismissal, there are two legal principles. One that we've already discussed. Misconduct, even misconduct related to a disability, is not itself a disability and may be a basis for dismissal, which is the Harpin case, the Zelnick case, and several other Court of Appeals cases. But another principle that needs to be emphasized is something that was alluded to earlier. Neal's request for a readmission after the dismissal is not a disability accommodation, but a second chance. In this case, a fifth chance to control her unprofessional conduct. The federal courts have repeatedly held The denial of such a request is not a cause of action on the ADA. And that's the Harpin, the Zimmick case, and as well as followed by several sister courts, such as Rose versus Lasky, which in that case, the cert was denied by the U.S. Supreme Court concerning that, but it holds the same principle. And turning to the second point, the district court, which relied heavily on Neal's stipulated facts, properly determined that there was no general issues of material fact.
Did y'all argue this case before the district court, or the court decided on the record?
Your Honor, it was decided on the record.
So this is the first time it's been argued.
Yes, Your Honor. And the record is over 3,000 some pages. It's very detailed. In the Eastern District, and as mentioned earlier, the Eastern District of North Carolina, it had stipulated facts, which is, I know, unique to some districts. So there was a whole stipulation of facts that he also looked at. Now, with the remaining time, I would just like to highlight a few things, points. First, in regards to, I think earlier, if I remember correctly, it was mentioned about how other students had not missed classes. There's no evidence of any alleged students that were similarly situated in this case. The same level, where they had exhibit the same level of misconduct and academic deficiencies, that they failed to communicate with faculty during a critical time period when faculty were deciding their continued enrollment status in the program, that they were referred to the Admissions and Retention Committee, or that faculty had to repeatedly provide assistance with classwork and internship for them to stay in the program. And as Your Honors correctly pointed out, in this case, ECU correctly and repeatedly tried to work with Neal, and she even Neal stipulates that faculty in a graduate program such as ECU has a duty to perform a gatekeeping function to ensure that only competent petitioners graduate. Fulfilling this duty requires programs not to graduate students who exhibit behavior that could pose a danger to the well-being of vulnerable social work students. She stipulated that on 878 through page 879 at section 23. I see that my time is running out. Can I just briefly make my very last point?
Briefly.
My final point is that the district court correctly applies this court's precedents that deference should be given to the university's academic judgment, especially healthcare providers. The Supreme Court held in Regents versus University of Michigan versus Oregon that courts may not override an academic judgment unless it is such a substantial part of an accepted academic norms as to demonstrate that the person or committee responsible did not actually exercise personal judgment. This court has held that it's especially true when it comes to respect to academic decisions that are made involving students that are entering the healthcare profession, because conferring such a degree is attesting that the students are qualified to deal with potentially life and death situations, which is the Harpin case. And ECU here properly follow their state academic standards. A school is not required to graduate a student who cannot meet its requirements. The Supreme Court in Southeastern Community College of Davis held that anti-discrimination laws do not require an education institution to lower or to affect substantial modification of standards for its students. And I, Your Honors, would again like to respectfully, for these reasons, request that the court affirm the district court's decision in its entirety. If there are no further questions, I would like to thank you for your attention.
Thank you very much, Ms. Totten. We appreciate it. Mr. Barfield?
Please, court. Judge, Ms. Totten made a statement I think is very important. She said Judge Britt looked at both sides. That's exactly what happened. Looked at both sides and took one. First point, stipulation that she should have had 4 supervisions was simply a stipulation acknowledging that that was the schedule. She didn't stipulate that she missed any supervisions on account of her own fault. I'll direct the court's attention to the record, particularly at pages 1161 to 68, 1182 to 1189, and also in 1123 to 1154. And this is the section of time in which we're talking among the faculty about the issue here. And in some of those emails, they're emails to and from Ms. Neal and Ms. Caraway, Professor Caraway, about field visits, and Professor Pearson about field supervisions. And in none of those emails does either Professor Caraway or Professor Pearson ever suggest at all that, by the way, you've missed supervisions because you missed them. They say we missed them because we had weather, we had this issue, whatever. On February 20, there was an exchange in which they're trying to, in fact, schedule field visits, and says, well, we weren't able to meet last week. The stipulation was that you should have scheduled them, but through no fault of Ms. Neal's, they were not held. In fact, if you look at the emails in the 1182, 1189 range, there are in there those emails indications that they, before they found out she was in the hospital, that they were going to reschedule those for a later date after March 18th. So there's nothing in the record that suggests that she had stipulated to or that she actually missed any field supervisions. With respect to Lynn Tyndall, she said she went missing because she was in the hospital. She also said that she made all of her field placements up to that time, and she made up all of her work thereafter. And we talk about Shin, Your Honor, and Zimic. Those are, although Shin is unpublished, it's quite apt. In Shin, he had good academic grades. They had separate grades for clinical. And in the separate grades for clinical, he was getting 1s and 3s out of 9. In the separate grades for clinical here, she's getting 4s and 5s out of 5. So, and the same thing is true with Zimic. Everything about Zimic was about his clinical presentations and his clinical performance. All of the evidence in this case, every bit of it, every last bit of it, is that she was exemplary in all of her clinical performance in the field. There is not one page in this record that says otherwise. And lastly, Judge, if I could have just a minute or two of indulgence, as Ms. Totten did. I think this is important to get to this issue of, well, she's a mental health professional. We got to be careful. This is what Lynn Tyndall said in her declaration. While many emotional and mental disorders, including bipolar disorder, may impair a social worker's ability to effectively and safely deliver services to clients, the same disorders do not in any way disqualify an otherwise qualified person from practicing social work when the symptoms of the disorder are adequately controlled by therapies, including appropriate medication. Indeed, it is one of the missions of social work to empower and facilitate persons who have been diagnosed with such disorders to carry on normal contributing and working lives, and no less in professional careers than in other occupations. This is even true when a social work professional's ability to safely and effectively provide service is occasionally compromised by relapse or onset of symptoms. In such case, the Code of Ethics specifically provides for resort to temporary cessation of practice while appropriate care is sought, and return to practice when that care has been successful. And lastly, this case is very unique in one other way. I don't think in any other case is there the degree of post-dismissal evidence that we produced in this case. Because she was supposed to be allowed to participate, she was to a degree allowed to participate. And she was also able to secure the services, not only of Ms. Tyndall, who was appointed by ECU, but a previously appointed ECU field instructor. And they evaluated her after the dismissal for all of her work using exactly the same standards that ECU applied, exact same field manual, the exact same learning agreement. And we have from that unique evidence in this case that because she was able to perform appropriately and well post-dismissal, that is evidence, and probably the best evidence, of whether or not at the time she was dismissed, she could have done so.
Thank you, Mr. Barfield. We appreciate counsel argument, and under our normal procedures, which we're not adhering to right now, we would come down and greet counsel and shake hands with you and tell you that you've done a good job right there. Well, I'll tell you from here that you've done a good job, and we appreciate it very much. And good to have you here. Madam Clerk, we'll take a brief break and you reconstitute the lawyers in here for the next case.
Thank you, Your Honors. Nice meeting you.
Thank you.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Thank you all. And ready for you can be seated. If you would. We're now prepared for the second case of the day. Tarashuk versus Givens. And we have Mr. Lindeman.
Thank you, Your Honor.
Good to have you with us, sir.
Good to be back here, Your Honor, in person. May it please the court. My name is Andrew Lindeman. I represent the appellants, Jamie Givens and Allison Harmon, who are two paramedics. Well, one's a paramedic, one's an EMT in South Carolina. Your Honors, this is undeniably a tragic case from a factual standpoint. There's no denying that. But what this appeal presents to this court are purely legal issues. What we have appealed is purely a second prong qualified immunity issue, which raises strictly legal issues for this court to determine precisely whether or not the legal duties that the plaintiff is claiming that these two paramedics had were clearly established by either United States Supreme Court law, Fourth Circuit law, or a broad consensus of other authority in September 2018. We submit that it did not, and that the trial judge or district judge erred in her analysis of the second prong of the qualified immunity analysis. This appeal asks basically two legal questions. Number one, and this is based on both the way the district court interpreted the plaintiff's pleadings as well as the plaintiff's specific allegations against the appellees Givens and Harmon. This appeal asks whether or not the law in this circuit was clearly established in September 2018, such that a paramedic would have known, an objectively reasonable paramedic would have known, been placed on fair notice of a constitutional duty to transport a mental patient to the hospital. And second of all, based upon the allegations that have been made by the plaintiff, whether or not it was clearly established in September 2018, whether a objectively reasonable paramedic would have known that there was a constitutional duty for the paramedic to intervene with law enforcement and prevent law enforcement from removing the subject from the scene. Those are the issues that were specific.
So are you saying that those are the constitutional rights that on the first prong and that you don't contest those?
Well, the first prong was contested. Judge Childs found that there were factual issues.
Right, but you say in your briefs it's not an issue.
It's not an issue in this appeal because this is an interlocutory appeal and we can't challenge the sufficiency of the evidence under the Berton's case, if I'm pronouncing that right, and the Johnson case from the U.S. Supreme Court. So we're not conceding those issues because this is an interlocutory appeal under the Mitchell case. We cannot be challenging the first prong. So this appeal is limited to the second prong because that presents purely matters of law. And yes, to answer Your Honor's question, those are the constitutional duties that have been pled on page 74 of the record, paragraphs 282 and 283 of the plaintiff's complaint.
Well, what about paragraph 280, where they say that the defendants here were both deliberately indifferent to the decedent's obvious mental health needs in violation of agency policy by not taking them for a mental health evaluation?
Well, that's essentially a restatement of paragraph 282, which again, they're saying there was a duty to transport Mr. Tarashuk to the hospital for a mental health evaluation. That's reiterated in 280. So
Paragraph 280 can't restate paragraph 282 because 282 comes after 280.
Well, I recognize that, but it's phrased in the same way. That the allegation there is that there was a a duty to take,
Right.
this is from 280, to take Mr. Terrace
Right.
to the hospital for a mental health event.
And that duty is the same one that we found existed in the Cinta case. Correct?
The Cinta case,
Yeah, I'm probably pronouncing it wrong.
the Cinto case was obviously didn't involve paramedics, didn't involve anybody in.
Does that matter? The right is about the pretrial detainee.
Well, in Cinto,
This was a pretrial detainee, correct?
well, we dispute that.
No, you don't. You concede that in your summary judgment papers and in the consent order that he was in the custody of the deputy and also that he was a pretrial detainee.
One of the appellants does concede that for a first prong analysis. This is a second prong analysis. It's immaterial, I would submit, Judge Thacker.
Which one do you say concedes that? Harmon?
I believe it was Harmon who
Okay.
approached the issue based upon it being a pre.
What about in the consent order signed by Givens where she conceded that he was, quote, in the custody of the deputy when she arrived on scene?
Well, Your Honor, again, that is the facts of the case all go to the first prong. This is purely a legal question with the second prong. So what we're looking at, the second prong, I would submit
Right.
what an objectively reasonable paramedic would believe. It's not a subjective standard. So
And the legal issue is that a pretrial detainee is entitled to for the paramedics on the scene not to be indifferent to his medical needs.
it requires, yes, a pretrial detainee is, you must provide medical care to a pretrial detainee.
For
In this
our
particular
purposes,
case,
for our purposes today, we assume that it's a fact is given by the district court that with a legal conclusion that the decedent was a pretrial detainee.
well, and again, that is, as Your Honor just said, it's a legal conclusion. In the footnote, in her opinion, Judge Childs relies on this case in Young versus City of Mount Rainier.
Isn't that a fact you have to accept? You have to accept that you can't be contesting that for purposes of this appeal.
Well, we're contesting it from a legal standpoint and determining whether the law was clearly established.
We're talking about the clearly established law, but the fact he was a pretrial detainee, that's not a legal question.
I think it is, Your Honor. What the status of the individual is, I would submit, does present a question of law.
Okay, this incident happened in 2018, correct? All right, and in 2016, the Fourth Circuit in Cinto said the right of prisoners to receive adequate medical care and to be free from deliberate indifference to their known medical needs is a constitutional right at issue. That was 2 years before this. So before the incident, so how was it not clearly established for these EMTs?
Well, Cinto, first of all, was a prisoner case. It was a convicted prisoner case. It was under the Eighth Amendment. Number one. Number two, what the Supreme Court has said and said a number of times since Cinto, in the Casella case is one that we've cited, that they admonished the circuit courts that the law is being looked at
Right.
with too great a generality. And this is
And there are 2 Supreme Court cases after Cinto that say that, but there are also Supreme Court cases before Cinto that say that. And Cinto is still good law, correct?
Cinto is good law, but again, it does not deal with a situation such as what we have in this case, where you're dealing with paramedics who are out on the scene. There's no arrest. The person is never taken into custody.
The person was in custody when they arrived on the scene. The person was in custody when they arrived on the scene. They took him out of a police car into the ambulance. He was in handcuffs.
He was, well, by the time I believe that the paramedics got there, he was no longer in handcuffs.
But he was in the police car in the custody of the police officer or the deputy.
Right, and there, he was not under any type of criminal investigation. He was never.
But he was in
charged.
custody.
Yes, he was.
That's what Judge Thacker asked you. If he wasn't in custody, you said yes.
That's correct. But again, what?
So if you're in custody, you're a detainee. You're in custody. You're in custody. You're in custody.
That's correct. But what is important for this case is to look at what an objectively reasonable paramedic would have believed.
And you're saying it's a 14th Amendment standard rather than an 8th Amendment standard.
It is a 14th Amendment
And
standard.
and you're saying there's a material difference between the two?
What I'm saying is you have to look at the specific facts. You have to evaluate the second prong of the qualified immunity.
But you have to give them the facts. The other side gets the facts for purposes of your interlocutory appeal.
And that's why, and again, that's.
You can't be coming up here with a factual dispute on an interlocutory appeal for qualified immunity.
Totally agree with you.
Just a legal point, as you've said at the beginning, it's strictly law.
It's a legal point.
It's strictly law. And you characterize it in your statement of issue. You say the question is whether the decedent's 14th Amendment rights were not clearly established, such that paramedics in the appellant's position would have fair warning that their conduct toward the decedent was unconstitutional. That's the way you characterized it in your brief there, which is different than what you said here earlier this morning.
Yeah, I don't believe so, but with all.
Well, maybe it's not materially
all
different, but
respect.
it's different terminology.
What I am suggesting this court is based on what the Supreme Court has cautioned in Casella and other cases. You have to look at the clearly established law with specificity.
Clearly establishes the right terminology for
With
sure.
specificity in this particular case, you have to look at whether there was a constitutional duty to transport Mr. Tarashuk to the hospital. What's important to recognize.
Well,
unlike
it seems
cases
like to me we're kind of going around in circles on pretrial detainee and whether or not CENTO is the law. I mean, you have to accept that that this individual was a pretrial detainee, or we have a very short argument today. And the same thing is, you may well be right that the level of specificity is too broad, but CENTO is the law. That's the law that applies to our case. And that's where we go from here. So it seems like to me, the first prong of the analysis, which you say you don't contest, deals with the constitutional right, which is stated to be deliberate indifference to his mental health evaluation. And then they give examples in the complaint. So the manifestation of what happened to make deliberate indifference to me that's not a separate constitutional principle. It's a matter of proving how the constitutional right was violated. Isn't that correct?
Well, yeah, the first prong is whether or not there's been a constitutional deprivation, and Judge Childs found that there are issues in fact in dispute that preclude a decision on summary judgment. So we haven't conceded any issues on the first prong. What we're saying is when you look at the second.
Right. I mean, you can go to trial and argue about whatever you want to, but for purposes of summary judgment, you're not contesting what the constitutional right is.
We are contesting whether or not the constitutional right that has been asserted and found to apply in this particular case.
You have to admit
For
purposes of your appeal, you need to admit that there was a constitutional violation, but say the right wasn't clearly established.
That is correct.
So, but you're trying to contest the constitutional violation.
I am not.
Well, you are in your arguments. You keep saying they allege a constitutional. They have alleged. Well, for purposes of your argument, they have a constitutional violation. And your argument should be that the law wasn't clearly established.
Basing the constitutional right on what the district court said, which was based on the pleadings. And she said specifically, Tarashuk alleges in his substantive due process rights under the 14th Amendment were violated specifically because defendants Harmon and Gibbons were deliberately indifferent to his serious medical needs by failing to transport him to a hospital and allowing Dorosky to take him from the ambulance. So the constitutional rights that are being asserted here is a constitutional duty to be transported to the hospital and a constitutional duty to intervene with law enforcement to prevent the law enforcement officer from removing them from the scene. That's the constitutional rights with the level of specificity that the Supreme Court requires. Those rights are not clearly established based upon United States Supreme Court law, this circuit's law, or a broad consensus of authority in September of 2018. That is our position. And there have been no cases cited that support any type of clearly established principles during September 2018 that would support a finding that that constitutional right, as articulated, was clearly established. And I see my time is up. I'll continue on rebuttal. Thank you.
You've saved some time. Thank you, Mr. Linderman. Ms. Calloway?
Good morning, Your Honor. May it please the court. I'm Jordan Calloway along with Russell Burke. We're here this morning on behalf of the appellee, Paul Tereshuk Sr. The way that the paramedics Jamie Givens and Allison Harmon interacted with Paul Tereshuk Jr. on the night of his death is the height of deliberate indifference. Despite reports of his bizarre behavior, they failed to take even minimal steps to address his mental health status. Instead, they shoved an ammonia stick up his nose and cursed at him. Harmon even described contemporaneously her indifference. She's caught on video specifically saying she'd rather be at home asleep as opposed to dealing with his mental health crisis. Under the principles this court has established in Skinto and in other cases, ignoring, mocking, and abandoning a seriously ill detainee violates his substantive due process rights. Appellants argue today that they lack fair notice.
How do you frame the question of what the clearly established constitutional right needs to be?
Your Honor, it would be at the level that was found in Skinto, which is the duty, the duty to receive adequate medical care and be free from deliberate indifference to their known medical needs. So that applies to prisoners and applies just as much to pretrial detainees. I could cite for the court several instances where this court has says that it applies both to detainees under the 14th Amendment to the same extent it does under the 8th Amendment to prisoners, and also that it applies to the same extent to mental health issues as it does to physical health issues. And so that is Fourth Circuit law. It's also been established in this circuit for a long time. And that is the law of Skinto. And that's really the issue here today. This is an argument against precedent that you're hearing from the opposing side. They're arguing that Skinto was wrongly decided. But I think they're also sort of suggesting that Skinto has somehow been impliedly overturned by Kilsa and Emmons. But let me address that for a second. Neither Kilsa nor Emmons said that Hope was wrong. And in Hope versus Pelzer, the U.S. Supreme Court said that you don't have to have a case that has the precise same facts. In fact, Hope rejected the standard that would require a case with materially similar facts. And Hope remains good law under Supreme Court precedent. And so since Skinto has not been overruled by Emmons or by Kilsa, I'll also note one other thing about those two cases in particular. Those are Fourth Amendment excessive force cases. And in both instances, the Supreme Court said that that phrase excessive force is of such that you do need maybe more specific facts there. But there's never been a Supreme Court or Fourth Circuit case which made a similar statement as it related to the deliberate indifference standard that applies to a detainee's serious medical needs. And so that is what makes those cases not necessarily different, but shows that they don't in any way even suggest that they impliedly overrule Skinto. Let me also say this about Skinto. Skinto was not writing on a blank slate. When they defined that right at that certain level, they did so because Eco versus Shreve had already done so. And the Fourth Circuit had already done so in a previous case. What they said in Eco versus Shreve is that you don't have to define the right of a prisoner's right to be decontaminated from pepper spray after he'd been sprayed 4 times, but instead you define the right as the right to receive constitutionally adequate medical care and for them not to be deliberately indifferent to that serious medical need. And so Skinto was not writing on a blank slate. It's also consistent with other Fourth Circuit precedent that we've cited in our brief, the Booker versus South Carolina Department of Corrections cases.
Well, as I understand your opposing counsel's argument, he says that he doesn't contest the general principle that a pretrial detainee there cannot be deliberate indifference to the medical needs of a pretrial detainee. But as I understand the argument, he says when you look at what's clearly established, you look at the specific manifestation of what the deliberate indifference is. And here he says one of those examples is quoting the complaint, the discontinuation of care and abandonment of the decedent without his consent and without providing further administration of care. And as I understand it, he's arguing that on that specific point, there isn't clear law at the time that the incident occurred. So what's your response to that, assuming I've characterized it correctly?
Your Honor, a couple. First of all, that Skinto, I believe, even on the facts, it has clearly established law on that particular issue. Because think about one of the incidents that was in play in Skinto. This individual prisoner was having a medical emergency. He had bloody vomit and an issue of incontinence. And the prison doctor comes by, sees this, can visually see it, and as it was alleged by the prisoner, that he then looked at the prisoner with disgust and walked away. That is, he ignored the need, he effectively mocked the individual, and then he discontinued or abandoned him walking away. And that is precisely what we allege here, that these, or not what we allege, what the court found the record supports, that in this instance, these paramedics basically ignored the fact they knew he had bizarre behavior. They knew that he had all these other issues, but yet they didn't do any sort of minimal mental health analysis on him. Then they mocked him. The Jurowski's video inside that ambulance is disturbing, Your Honor, to hear the things that they say to this man and how they mock him during their encounter with them. And then they do discontinue their care and just sort of walk away. So one, on Skinto, I think the facts, Skinto is actually a very good factual analogy for the case we have here. And so I think also, if you look to other Fourth Circuit precedent.
Well, you've got two components, as I understand the law at this point. One is an objective analysis. Was it evident that there was a health problem? And I think there's a good argument when you look at the facts in the video that it would have been self-evident. Then it goes to the subjective factor. So what did the two defendants in this case know about it? Were they aware that this mental health condition was a factor and then acted regardless of that? So tell us what your best evidence is on the subjective factor.
Okay, yes, sir. I believe that it would be the fact that both of them admitted in their depositions and their statements, in other words, that his behavior as described to them by Jurowski was either bizarre or weird. Jumping on the tractor trailer naked, running around saying these crazy things, that was bizarre or weird. Then when you look to how the assessment they're supposed to do, they're supposed to determine if this person has altered mental status. Two of the factors of altered mental status include lethargy and bizarre behavior. And so by their own sort of standards, then they have to consider him to have altered mental status, which is a serious health need, both under their standing orders and under South Carolina law. We cite a South Carolina statute and regulation, both of which don't allow you to discontinue care when they're in a serious medical need like this. I would like to say one point about this, though. That subjective factor, I do believe, goes to the first prong of the clearly established, of the qualified immunity analysis as to whether there was a constitutional violation. So under that 14th Amendment standard, you do have to show both the subjective and the objective standards in order to show that there is a constitutional violation. As I understand the appellant's position, they don't challenge that here. They're only challenging the clearly established element, that second prong. In fact, they were very effusive in their reply brief and sort of chastising me for even discussing that stuff in our brief, saying none of that's on the table. We're just dealing with clearly established here. And so I do think there's plenty of evidence in the record to support the district court's finding on the subjective element, but I also believe that that's not a portion of their appeal as they've described it in their briefs.
Even if that wasn't a given for our purposes today, if there's a factual dispute, that takes care of what we have to consider today, doesn't it?
Absolutely, Your Honor. Any factual dispute has to go to a jury, even on the qualified immunity question. And again, with the limited scope of interlocutory appeal for the denial of qualified immunity, they don't get to raise those here like anyway. And so that's just not on the table here today either. Let me mention a few other Fourth Circuit cases that I think would help.
If they're trying to challenge your facts in this appeal, does that undermine jurisdiction for the appeal?
Yes, sir. As we say in our jurisdictional statement, there is Fourth Circuit precedent, the Williams versus Strickland case, which discussed this, and Johnson, the Supreme Court case, which discussed this, which says that the court can deny or can dismiss the appeal, finding it lacks jurisdiction over those questions. Evidence sufficiency questions are not available in interlocutory.
So you have to get the benefit of the facts in order for them to get jurisdiction to argue the appeal.
Yes, we get the benefit of the district court's finding on the facts. They are limited in their arguments here. Jurisdictionally wise, this court is.
Do you get the benefit of the district court's facts, or do you get the benefit, or you also get the benefit of the facts revealed in the record, viewed in the light most favorable to the plaintiff?
Yes, sir.
Is that in addition to what the district court found, or is that something different than what the district court determined? I'm just trying to get you to tell me what your position is.
Yes, sir. They are what the factual findings by the district court are consistent with the record. We would also get the presumption in our favor as to everything that's in the record. That
Well, the court was the court making findings, or was the court reciting the facts from the record in the light most favorable to the plaintiff?
I don't know if I perceive a big difference
I
between.
mean, usually findings, I see findings that judges make after they had a hearing or something and heard witnesses, like on a suppression motion or something.
Yes, sir.
You didn't have anything like that here.
Yes, Your Honor. I think it's fair to describe that the court found the facts or considered the facts in the light most favorable to us.
Recited the facts.
Recited the facts in the record in the light most favorable. That's which is
viewed them in the light most favorable to you and made the ruling. And they're contesting the ruling, and to do that, they have to accept the recitation of the facts.
Exactly, Your Honor. And that includes the fact that he was a detainee, which they do basically concede. I mean, that's right in Harmon's briefing, that when she walked up with him, he was detained. Even if you look at the facts, we wanted to look in facts of light most favorable to us. When they walked up to him, he was in the back of the Rossi's car, which he describes as a transport cage. So he's in a cage when they find him. And then as they're walking into the ambulance, he begins to wander off. And then both the EMS and the police officer says, no. And so if custody means that you're not able to go off on your own, we certainly have plenty of evidence of that in this case. I do want to address some of their arguments on clearly established, one of which is that the court can't consider any policy violations in the determination of clearly established law. Now, I will concede this much. Clearly established law cannot be based solely on policy violations, but there's both U.S. Supreme Court precedent and Fourth Circuit precedent considering policy violations in determining clearly established law. I would point the courts to the Hope case and also this court's opinion in the Booker case. And in Booker, the court specifically said that policy violations can buttress finding of clearly established law in the precedent. And Hope said the same thing in considering policy violations to help a clearly established law instance. And there are plenty of policy violations here. In fact, I don't even think it's fair to necessarily call those policies. Those are standing orders on page 180 to 185 of the Joint Appendix. Each one of those has a signature of a doctor at the end of it. Those are standing orders that were allegedly ignored here by the EMTs. And that's important as it goes back to Skinto, because the other incident in Skinto was the denial of insulin, according to a doctor's standing order. So this inmate had insulin-dependent diabetes, and his blood sugar went up and down, and there was a sliding scale in the order as to how much insulin he was supposed to get based on his blood sugar reading. And the argument is that he should have gotten a certain amount and he didn't get any because this doctor denied it to him. And that is, in an instance, ignoring a doctor's order. That is precisely what we have here. Those standing orders on pages 180 to 185 are doctor's orders, and they ignored those. They just simply didn't follow them as it relates to the determination of altered mental status and what you do with a person who has altered mental status. Then those standing orders are not just standing orders, they're also South Carolina law. We cited both a state statute and a regulation that supports those conclusions.
And for our purposes today, we assume all that to be factually given. Correct?
Yes, their misconduct, yes, is taken as a given for the purposes of today's hearing. Yes, sir.
I mean, you all can argue about it all you want at trial, but for today's purposes, it's set.
Yes, sir. And that's supported by the record, and that was their allegations. Let me see if there's anything else here that we need to address. Your Honor, I took the court to not not necessarily accepted the argument that he was not a detainee, but I would be happy to go through all the case law that really does show that he was in fact a detainee, even if he was a non-typical detainee. They make a big deal out of the district court's footnote in the citation to Young. But if you look at Young in the citation to note 5.
What do you mean they make a big deal?
Well, they point to the footnote in the district court's order, which says that Paul was not a typical detainee. And they interpret that.
What page is that on?
Well, isn't this a threshold issue? I mean, if there's a genuine factual dispute about detainee status, how do we have jurisdiction? I mean, isn't that a threshold foundational question? What
Yes,
the
sir.
right is?
Yes, sir, it is. And Judge King, to your question, the footnote is on page 2890 of the record, second or third last page of the district court's order. Young said even if he
What footnote number was it?
Joint appendix, page 2890.
2890. You're giving me the JA thing. I'm looking at the opinion. All right. Page 16, 17.
Footnote 13.
All right.
And that's Young. And if you look at Young footnote 5, they said even if that individual was a non-typical pretrial detainee, same duty was owed to him. That is to say, as soon as he was taken into custody by state authorities, whether that was done for criminal investigatory purposes or for some other purpose, they still had a duty to provide him constitutionally adequate medical care that is not to be deliberately indifferent to a serious medical need. Now, as I understand the reply brief, their position simply is, well, what makes Young different is that in Young, it was the officer's conduct which created the need for medical treatment. And that Young does not make that distinction. But I'll also note that Young cites Buffington. And in Buffington, the court says basically the exact same thing. But in Buffington, the reason the person was taken into custody, civil custody, is because he was suicidal. And so once they took him into custody, they had a duty to provide minimally adequate medical care for him, which is in that instance was just to monitor him. But my point is, in Buffington, they certainly didn't create it. They still had an obligation to provide constitutionally adequate medical care to him. And so this notion that Young is just limited to instances where the officers create the need for medical care just doesn't hold up to the case law. And so we've got plenty of cases to establish that. You know, I'd also note there are, by defining these two rights, this notion that it's just about transporting to the hospital, just about intervening with Dorowski, that is not the limitations on our claim. If you look at paragraph 280 of our complaint, we allege 10 different ways in which Harmon and Givens were deliberately indifferent to his medical needs. That includes elements of the assessment itself. Like, for example, they acknowledged that they falsified the record afterwards and said that he was alert ×4. And they not only didn't determine that, they didn't even ask the questions or all the questions you would need to determine that. They asked him his name, sure. And I think they perhaps asked what he was doing out there that night. But alert ×4 means that you're alert to person, place, event, and one more that I'm forgetting. But they didn't even ask all questions to even address all 4 of those things. And so when you're talking about a minimally adequate, constitutionally adequate analysis, they didn't even ask the questions. We haven't even talked this morning so far about their misuse of the ammonia stick, which they stick up his nose for several minutes in violation of every way in which they were trained. They admit they misused that. And then they said that he would have to give his name before they'd even remove it from his nose. That too constitutes deliberate indifference. Remember, under the 14th Amendment, no pretrial detainee can face any form of punishment. That could very easily be determined to be a punitive action, the way they were using that ammonia stick. And again, we haven't even got to the DHEC orders, where they admit to all of these things. They admit that they didn't do the proper.
They got to the what orders? I didn't understand.
The DHEC consent orders.
The agency.
Yes, sir.
Yeah, okay.
Where they each acknowledged that they're subject to discipline. They ended up being suspended for these things. They admit that their assessment was improper. And they admit that they did misuse the ammonia stick. They admit that they misrepresented these things in the records. They admit that they abandoned their patients. We have Fourth Circuit case law, which says that if you ignore, mock, and abandon your patients, that qualifies as deliberate indifference to a substantial medical.
You say they falsified the records too?
Yes, sir, they did.
What's the impact of the falsification of records in a 1983 case?
Your Honor, I think it does help support the notion that they were deliberately indifferent. I know it's after this case, but the Fifth Circuit considered a case just last year, the Kelson case, where they noticed these very same things. They falsified the records and found that at least at the complaint stage, supported the notion that they were deliberately indifferent. If they're going to cover it up afterwards, it would suggest that they were acting deliberately when they performed the act that was misconduct in and of itself.
So it goes to proof of the deliberate indifference.
Yes, sir. I see my time is about up. If there is no additional question,
You don't have to take it all if you don't want to,
Mhm.
Your Honor, we would ask the
but
court.
you're entitled to it.
Thank you.
Thank you very much, sir. We appreciate it. Mr. Lindeman?
May it please the court. Your Honor, Mr. Callaway points to paragraph 280 of the complaint suggesting that there were additional constitutional duties or issues at play in this particular case. I would remind the court that this was a substantive due process claim. If you look at some of those particulars, they talk about discriminating against him. That's not a substantive due process claim. Mocking the subject, again, mocking has never given rise to a constitutional.
Well, that'd go to prove the deliberate indifference, just like falsifying records.
It would
Absolutely.
go to a first prong issue. Again, we are bringing a second prong appeal here because again, that is all that we can appeal because that is a legal issue. And what we focused on is what the district court found. And the district court found, this is on page 16 of her order, that the plaintiffs alleged that Harmon and Givens were deliberately indifferent to his serious medical needs. She says, quote, by failing to transport him to a hospital and allowing Dorosky, the deputy, to take him from the ambulance. Those are the issues that she ruled upon at summary judgment. And those are the issues.
The sentence is actually that's what he alleges that you just read.
That's right. And that's what.
I thought I heard you say that the court found that.
No, that's what she is focused on.
No, she says that's what he's saying.
That's correct.
She didn't say that's what I'm saying. I'm talking about the she there is Judge Childs.
And her clearly established law analysis.
May well be right, but it's not her. It's not her saying that's what the issue is. It's their claim that that's what the issue is.
And that's what she addressed at summary judgment. And so the point being, and we're not arguing that Skinto should be overturned. Skinto is a.
Why are you saying it wasn't clearly established, that the constitutional right was not clearly established?
Not clearly established because you have to look at the right with specificity that the Supreme Court requires. You have to look at whether there's a constitutional right to transport him to the hospital.
You're saying there's never been a case like this.
There's never been a case.
It might not be, never be, it might ever be another one. As weird as this.
Additionally, Judge King, there's no law in South Carolina that authorizes.
I hope there's never another one like this.
You're saying that it was not clearly established to Harmon and Givens that what they did was wrong.
That's right.
Then why did they falsify the records?
That from a constitution.
They must have known it was wrong. Why would they falsify the records?
Well, again, that's an allegation that they falsified the records.
Well, I thought they conceded they falsified the records. They in the consent order, they admitted they falsified the records.
Judge Thacker, there's a.
And you admit that for purposes of this appeal.
For purposes of a prong one argument, yes. But
there you go.
Being, those issues also go to state law claims. There's state law claims involved in this case. I mean, that's a standard of care issue. That's a medical malpractice issue. Those are all state claims. The focus of this case is whether or not there's a constitutional right that has been violated, number one. And number two, if there is a constitutional right, whether it was clearly established. And the right that they're claiming is a right to have been transported. There is no law that supports that. Neither South Carolina statutory law supports that. Mr. Callaway keeps arguing that there is, but Your Honors, 44-17-410
No,
provides for the
no,
emergency.
they're saying that there was deliberate indifference. And that the part that you read to his serious medical needs by failing to transport, that there was deliberate indifference.
There's no legal right to transport him in September 2018. There cannot be a constitutional deprivation based on a failure to transport. There's no law that allows for it, that supports it. The case law that we submitted, including the cases out of the Seventh Circuit, the Payne versus Kaysen and the Salazar case, support our position. And as I was just indicating to the court, South Carolina has a very specific statute that satisfies procedural due process about how you can emergency admit a mental patient. And it does not provide for a paramedic to have that authority. It only allows for a court to have that authority after certain procedural aspects are taken care of. So what they're arguing that we didn't do, we couldn't have done legally. So therefore, it can't support a constitutional claim of deliberate indifference.
So
And
is
again-
your argument under South Carolina law, if the two defendants in this case had looked at this individual there in the ambulance and said, you know, there's obviously a mental episode here, or he wouldn't have been riding the tractor trailer naked down the interstate in the middle of the night. We're going to take him to somebody who knows more about mental health than we are in order to try to assess the situation. Are you saying if they just drove the ambulance with him in it to a hospital that he had a legal cause of action against them for abduction or
false imprisonment.
false imprisonment?
Yes, Your Honor.
What?
And quite frankly, if the officers had arrested him, that'd be a different story.
Wait, don't
He's
their
not
own,
placed under arrest. The paramedics have no right to arrest.
don't their own protocols say that paramedics are required to transport someone with an altered mental state to the hospital under implied consent?
That is an Orangeburg protocol.
Right, that's what I said.
Yeah, it's not law. It's
Right, but their own so they don't have to follow their own protocols?
Constitution that does not give rise to a constitutional duty.
Do they have to follow their own protocols?
I would submit that it's contrary to state law, Your Honor.
So they don't have to follow their own protocols?
That's the position that I certainly would take on that particular issue, but that is a state law issue that goes to the state law claims for which Judge Childs deferred any type of ruling. So when we focus purely on the Constitution, the United States Supreme Court, as well as this court in Law versus South Carolina Department of Corrections, have made it clear that a violation of policy, this isn't even a policy, this is a protocol.
Well, what's
Written by
protocol and a policy sound to me like the same thing.
Well, I mean, bottom line is that does not give rise.
Well, he argued that the law that policy violations are relevant on the clearly established issue.
Well, they're not, you know.
And you say they're not.
Look at Law
Well,
versus
with
South
you-
Carolina
all
Department
right.
of Corrections. Look at the Caressi's
All right.
case from the United States Supreme Court. They've spelled that out pretty clearly.
Mm-hmm.
And then on this whole idea of intervening, having a duty to intervene and stop law enforcement from taking this guy away and releasing him, paramedics don't have that constitutional duty.
Ms. Harmon might as well stay asleep then, under your theory. She wanted to go back to sleep. Was she the one that wanted to go back to sleep? She might as well stay asleep, not even come out and bothered with this gentleman. Because she didn't have to follow any protocols.
I am not suggesting that, and that's for another day, whether or not the plaintiffs have a remedy under state law. The question before this court is whether or not it was a constitutional duty under substantive due process, to either transport or intervene with the police officer. And our position is that law was not clearly established. We're not suggesting, standing here saying that the plaintiffs will or will not prevail on a state law claim. State law torts are obviously available to address these type of issues. Thank you.
Thank you, Mr. Lindeman. And we appreciate the arguments of counsel, and the case will be taken under advisement and determined. We would normally at this time rise from the bench and go into the well of the court and greet counsel. And thank you personally, but we will, we're not doing that these days. We hope to be doing that the next time you come. But we thank you very much. It's good to have you here. Thank you for your work. And Madam Clerk, we'll take a brief recess while you reset.
Of the United States Court of Appeals for the Fourth Circuit.
Be seated. I want to welcome you all to the Fourth Circuit. It's good to have you here, and we look forward to the arguments of counsel in the case of United States versus Patrick Andrew Groves. Ms. Toma, good to have you with us.
Good morning, Your Honors, and may it please the court. When Mr. Groves appeared for his sentencing in February of this year, he had already been in pretrial custody as long as the low end of his unenhanced guideline range. He could have and should have gone home. Instead, he's sitting in a federal prison today because the district court determined that his 2015 federal conviction for aiding and abetting his co-defendant's distribution of a controlled substance was a controlled substance offense under the sentencing guidelines. That decision was erroneous for 3 independent reasons, any one of which would suffice to require remand resentencing. First, it was overbroad by substance under United States versus Pope. There's no dispute here as to the fact of the framework, I believe. I think all that's in dispute is a purely legal question of whether Mr. Groves' statute of conviction, 841A1C, is divisible by controlled substance, by each individual substance. It is not. The statute on its face very clearly says a Schedule 1 or 2 substance. This court has confirmed that crack cocaine is not an element of a C offense. Other courts of appeals have said so. The Solicitor General said so, and just last year, the Supreme Court said so in Perry. When a decision like that exists from the highest court, this court need only follow what it says. And that is enough to resolve that issue in Mr. Grove's favor. His 2015 conviction is overbroad by substance under United States versus Hope, simply because in 2015, at his sentencing, a Schedule 1 or 2 controlled substance is broader than it was or is in February 2022 when he was sentenced. In terms of the second reason, it was overbroad by conduct under United States versus Campbell because 841A1, just like the
Now, he pled guilty to count 5 of that indictment, 9-count indictment, which was distribution of a cocaine base,
aiding and abetting the distribution.
aiding and abetting the distribution of a quantity of cocaine base. And that's what you're saying, that's not a controlled substance offense.
No, because the inclusion of which particular Schedule 1 or 2 controlled substance it happened to be.
And you're relying on your claim that aiding and abetting is different.
Well, this particular argument is about United States versus Hope, and that's a separate one from the aiding and abetting.
But you started out by where your brief setup, you're talking about, you started out with aiding and abetting, and you're saying Campbell helped you, that dealt with the attempt offense.
There are
So you're reorganizing it here.
I did. In the reply brief, we sort of switched order to start with the Hope
Right.
argument just to help with flow.
Mhm.
So that
So that, before you leave that, the government says that that argument is subject to plain error review.
no, we disagree with that.
Well, you didn't raise it before.
Mr. Groves in district court argued that his conviction was overbroad and that it wasn't a controlled substance offense under 4B1.2. Granted, after his sentencing occurred, their Hope came out and that added a third reason why it was overbroad. But even, under any standard that I have seen from this court, including Robinson, including Hope, including the dissent in Hope, any of those standards, this is sufficient to preserve that third issue for plain error review because he had done what was required under this court's precedent.
So all he had to say was it's overbroad. He didn't have to say anything about descheduling drugs or anything else.
Not according to this court's precedent, no. And I would also add that even if plain error review did apply, it's easily met here. I mean, it was met in Hope, even when that was certainly much more new than it was here. Either way, we would certainly meet a plain error review, even if that standard applied.
Now, is this the position on hemp that you're arguing about?
Yes.
Okay, that's the overbroad. That was never presented to Judge Bailey.
Overbroad, but correct. That's right.
And what's that other substance that I can't pronounce it?
I struggle to pronounce it myself. I think
Okay.
it's
I warm to you, buddy. I can't pronounce it. But it's the hemp part that I can pronounce.
So
You're saying by deleting hemp from the list, that undermines all of these controlled substance offenses around the country. How many million of them would there be?
I don't know that I know a number around the country. I just can say that many circuits have now done that in the time that since Hope came out and now, and we've cited several circuits that have absolutely done that without problem. So this is certainly not, any sort of, for example, the First Circuit in Abdulaziz applied that specifically to the guidelines, and so did the Ninth Circuit in Batista. I mean, this is something that's pretty well established, I think, at this point, even though it was not when Hope came out.
So you're saying it's now well established that there can't be a 841A conviction for a controlled substance?
I think it's pretty well established as to the timing framework that when we are asking if a particular portion of the defendant's prior is overbroad, that it's pretty well settled at this point that we are comparing the element as it's defined by the law in place at the time of the conviction versus what that same element is at the time of sentencing. I think there's a timing framework that's become well adopted by the circuits.
I would like to hear your argument based on Campbell.
The second argument is that it's overbroad by conduct because 841A1 overbroadly, just like the West Virginia statute in Campbell, overbroadly criminalizes attempted transfers in the definition of distribution. Now, under Campbell and this court's recent decision in Locklear, most of the government's arguments on this point are foreclosed, we believe. The only question really for the panel now is whether the government has, quote, distinguished the operative statutory language from that in Campbell. And we think it's failed to do that simply because an attempted transfer and an attempted distribution from 8028 and 846 really cover the
So
same.
you're not talking about aiding and abetting now, you're on this other argument.
You giving up on aiding and abetting?
It is third.
She's responding to because I asked her for her Campbell argument. I think that's why.
We don't believe that there's any difference in the conduct that those two things cover. And I think that's true. Whether you look at a historical statutory definition that has been used for almost over 100 years, probably in the older versions of the statutes, or whether you're using the plain meaning of attempted transfer, either way, it comes out the same. Those two things cover the same conduct. The only discernible difference is a defense that is irrelevant to the category. So we don't.
So if we accept your viewpoint, what happens to section 846?
Nothing happens. I mean, section 8, an attempted drug offense, to be clear, was already excluded under Campbell. This does nothing new to 846. That was, I think, already pretty well established that attempt offenses, and I would include 846 in that, were already excluded under Campbell. And I think that district courts, at least to my knowledge, have treated it that way as well. However, the government really hasn't argued anything about that, and neither have we. As far as there is one point that I want to make about even if the government's interpretation was correct, and even if there was some minute difference in the conduct covered by an attempted transfer and an attempted distribution, we would still win because ultimately what Campbell makes clear is that 4B1.2b has a very clear definition, and it says that a controlled substance offense means distribution. And so anything that is not distribution, anything less than distribution, whether it's an attempted transfer or an attempted distribution, if it is less than distribution, it does.
But he was convicted of distribution.
He was convicted of aiding and abetting the distribution.
Well, he was convicted of distribution. Aiding and abetting and the substantive offense are the same thing. That's what the law is.
I would like.
That's what the law is. One of those cases I wrote in Old Barefoot. We plowed this furrow, but it's been the law for ever. The statute says aiders and abettors are punishable as principals. I mean, I would think that would supersede anything you want to argue about in the guidelines. That's the statutory provision in Section 2.
It is.
It's been the law forever.
It has indeed.
You're an aider and abettor, you're punishable as a principal. So where you look at them as a principal, aid and abetting distribution, they distributed cocaine, base.
I would agree with Your Honor that for a long time it was foreclosed. And I would very briefly say that.
And an attempt is a different thing. An attempt is not a completed offense. Aiding and abetting a distribution is completed offense.
The reason why aiding and abetting the comparison is different now, as it has been in all those prior cases, is because if you look at, for example,
Altered by what?
Buenos-Alvarez, the generic offense comparison, as the Supreme Court said in that case, is that you are taking the offense of conviction, which would include the aiding and abetting elements plus.
So you're saying the Supreme Court changed Section 2?
And on the other side of that comparison, because all 50 states and jurisdictions treat it that way, you would have a mirror image. You would have aiding and abetting elements and substantive offense elements. After United States versus Ward, for the guidelines purposes of 4B 1.2, specifically just 4B 1.2, that's no longer true, because what we have on the other side of that comparison is not a mirror image as it would be for something like a generic offense comparison in Duenas-Alvarez, in like Ali, this court's decision in Ali, and Comordo and Dinkins, and anything like that. What we have now is 2 aiding and abetting elements and substantive offense elements and ordinary meaning of distribution, which is far more limited than it used to be. And we believe that impacts how the result comes out. We think for the first time since Ward, the comparison is different, the outcome is different. But I need to address one thing very briefly before my time is up, which is the 994 issue presented by the overbreadth by conduct argument or attempted transfer.
Before you do that, I'm a little confused by your argument. Are you saying that now the elements of aiding and abetting and acting as the principal are now different?
No, I am saying that when you are making that comparison, for example, in Dozier, this court said that you must have both. You've got to have the elements of the inchoate might be a bad term, but those elements must also be there along with, and I don't think that you can ignore them. I also think that in this particular
I'm
case,
still not understanding what you say you're ignoring. If the elements for aiding and abetting and the underlying crime is the same, I'm not understanding what you are saying is different.
and it may be that we have to agree to disagree on that point because I need to talk.
Well, I'm not disagreeing. I'm just saying I
That's the
don't
law.
understand
What
your
the lady
argument.
you just said, you can't you can disagree. I guess you can. It shouldn't be the law. We can't change it.
I am saying that on one side of that comparison, you have the elements of aiding and abetting. And again, if you look at Mr. Grove's judgment order,
Aiding and abetting, the elements of aiding and abetting are the elements of the offense.
his judgment order lists.
That's what the case, that's what all the case said. They don't even have to put aiding and abetting in the indictment. And they can get an aiding and abetting instruction and they're charged together. If you charge the offense, you charge aiding and abetting. An aider or abetter is a principle.
So I need to talk about 994H, which is that first, we want to make clear that all of the arguments about that aside, there cannot actually be any 994H violation in this case because 994H by its own terms applies only to a sentence or a guideline range for a career offender. Mr. Groves isn't a career offender, so 994H does not apply in this case at all. There is no 994H violation. Even if it did apply, it doesn't do what the government claims because even if 994H binds the Sentencing Commission, we know from Dorsey that it cannot bind Congress. And here we actually have congressional action because what was amended was the guideline. The commission first promulgated a version of the career offender definition that enumerated 841 offenses. It was in the text of the guideline. And 2 years later, it took that out. And because it had amended the text of a guideline in so doing, Congress had to review and approve that change. And so whether or not the Sentencing Commission can violate 994H, Congress certainly cannot. It cannot and does not bind Congress. I see my time is over.
And you've saved some time for rebuttal. Thank you very much. Ms. Wagner,
Thank you, Judge King.
good to have you here.
To be here. May it please the court, I'd like to start with the arguments in the order that Mr. Grove's counsel raised them, if that's okay with the court.
Go right ahead.
The dispositive question on the IO food pain and hemp argument is whether 841 is divisible, which would allow this court to look at the 2015 indictment and plea colloquy from Mr. Grove's prior conviction. The answer to that question is that 841 is divisible. That includes B1C for at least 3 reasons.
So what's our standard of review here? As I understand opposing counsel's argument, she says she didn't have to raise anything specific in order to preserve it. I think you claim it's plain error.
Yes, we believe it's plain error review, that in hope, this court did not agree on the facts of that case. But we believe it is plain error review because while it is correct that Mr. Groves raised the overall argument that his 2015 conviction was overbroad and a categorical mismatch to the controlled substance offense definition in the guideline, he did not raise this specific issue. We believe that plain error applies, but really what we are anchoring to is that there's no error here at all. But we do believe that plain error applies.
But plain error is satisfied on the first prong of plain error, that we don't even get to the plain issue. If there's no error, that's what you say.
Correct, Judge, yes. And that's our position.
When you say 841 is divisible,
841 is divisible.
how is it divisible? How many ways?
At least it's divisible by means, but it's also divisible by drug type and drug quantity. And specifically, B1C is divisible in and of itself. It is not accurate to say that B1C, that the elements of B1C are that the government must prove any quantity of any Schedule 1 or Schedule 2 drug, because B1C itself covers more than Schedule 1 and Schedule 2 drugs. It covers GHB, which is a date rape drug, which in and of itself is a Schedule 1, but if it's included in a FDA-approved pharmaceutical, it's a Schedule 3. B1C also covers flunitrazepam, which is another date rape drug and a Schedule 4 drug. But more significant to the claims that Mr. Groves is raising is that B1C is limited not just by the mandatory minimum, well, I wouldn't even say limited by subparagraphs A and B, those set out mandatory minimums. But subparagraph B sets a whole different statutory maximum, lower quantities of marijuana. So Mr. Groves is arguing that his B1C offense could have unfairly included hemp. But in order to even address that, the court necessarily has to look at the 2015 documents, because Mr. Groves could not have been convicted of a B1C marijuana offense unless the government had not just alleged quantity, but also alleged.
I thought he was convicted of a cocaine offense.
He was, but he's making the argument that it could have been him. He could have been convicted.
Well, well, I guess with the question is whether we can go look at the indictment. And you've submitted the indictment. I don't know whether you filed it or not. You submitted it with a supplemental appendix.
Yes, Judge.
The indictment, but the only part of it that's pertinent is count 5. And he apparently pled guilty to count 5, which the only thing it refers to is cocaine base.
Correct.
And the judgment order says he pled guilty and was
Judgment
convicted of it, but it doesn't say cocaine base.
It doesn't say cocaine base. It
So
doesn't say Schedule 1 or Schedule 2. It could have been Schedule 3 GHB product. It could have been a certain.
Which one of those two documents control? Do you read them together? Or what do you do?
I think you read them together with the plea colloquy in which the agent the government made a proffer.
Yeah, but that's not in the record.
We have offered it in our supplemental appendix.
Oh, that's in there? Oh, that's that transcript you gave us.
Yes.
All right, so but it's filed as an appendix, but you never did make a motion to supplement the record.
I believe we did, Your Honor.
You did?
Filed that motion with our brief at the.
I thought you moved to file the supplemental appendix. Did you move to supplement the record as well?
I'm not sure.
See, there's 3 ways I see you could get this thing in. If one is that we got it in the appendix, but it's not part of the record, and the appendix is supposed to be drawn from the record. You could supplement the record under Rule 10E and get it before us, or we could just take judicial notice of it. At least the orders and the indictment. Now, whether we could take judicial notice of the transcript, I guess, but you could move that too, maybe. I don't know. But if you read the transcript, then you get he was convicted of cocaine base, just aiding and abetting the distribution of cocaine base. And is that undermined by any of the stuff that's happened since then? But to be able to look at that transcript, do you agree that the statute has to be divisible?
I believe in order for the modified categorical approach to apply,
We have to apply the modified categorical approach to look at what?
at the underlying documents from the 2015 case.
Well, why would we need to look at the indictment? That's in the public record.
But I don't.
We can take judicial notice of it.
Yes, Judge, but my understanding, and maybe I'm misunderstanding what.
I thought we could look at the indictment to be able to consider the divisibility issue.
I think, yes, I think this court made clear both in the majority opinion and the Judge Thacker's dissent and hope that you could look at those external sources.
This is where the Supreme Court says that the court can peak
Yes, Judge.
in order to do that. And so your argument, I take it, is that the structure of the statute itself lends to the modified categorical approach.
Yes, and I believe that's consistent with what this court has done in with respect to other state statutes that are structured in a similar fashion. In Dozier, it was the West Virginia distribution case statute. In Baugh versus Gonzalez and Cacalon versus Gonzalez, which Judge Gregory talks about in some depth in the Ward case. This court has previously concluded that the Virginia statute, which is set up with similar type penalty provisions, that these are divisible.
I understand that you argue that plain error applies and also that there was no error. But if we find that there was error, does the government concede that it was not harmless error given the alteration of the sentencing guideline here and the fact that he's in prison now longer than he otherwise should have been if there was error?
If there was error and it was plain, then I don't think there's an argument in the government's favor on harmless.
Thank you.
I do believe that we don't concede that the error was plain.
Right, I understand that.
Just briefly to address some of the cases that Mr. Grove cites, this court has never said that drug type is not an element of a B1C offense. In all of the cases that they cite from this circuit, Tillman, Collins, and Dolan, the court is talking about not an 841 offense in and of itself, but either an 846 attempt or conspiracy, and referring to what the government must prove under the baseline offense, which is not a B1C offense. The baseline offense, as the court explained in Tillman, is the 841A1 offense, which just says you can't manufacture, distribute, possess with intent to distribute a controlled substance. In the Dolan case, it wasn't even under Title 21. It was a travel and furtherance of a narcotics business under 1952. And this court said that there was no constructive amendment where the government didn't prove, it charged LSD, but didn't prove as between the drugs or what the drugs were as between LSD and mescaline, because both are controlled substances.
Your position is that the identification of the substance is an element?
Yes, Judge.
And that mean a controlled substance under Schedule 1 or something. You have to prove what kind of substance it was?
Yes, our position is that drug type is an element of a B1C offense, because if it were not.
And in a trial, you have to submit that question to the jury.
Correct, and that is how we charge them. I would say I haven't done
I remember a case, and I might muse a little bit here, that we lost on appeal from a case I tried. There was a conspiracy to distribute, it was an 846 conspiracy to violate 841, I guess, or something, to distribute marijuana and cocaine and heroin. And it's called United States versus Quixie, I think. and we submitted a general verdict on the, and the jury didn't find specifically which drug types or type that they conspired to distribute. And the court ruled that they got the benefit of the least punishable, so they got the benefit of being convicted of marijuana. And essentially, they couldn't be, and they vacated a sentence that Judge Hall had given, I think, for cocaine or heroin. Was that there was a question of whether it was a 20-year crime or a 5-year crime, and they got the benefit of it. So we had to prove, and that has that ever changed, that kind of principle?
I don't believe so. The most recent decision that I'm aware of is not a appellate decision, but it's from a district court on a 2255 motion, United States versus Brown, relying on this court's decision in Rhines in 1999. And in that case, it was a like the case you've just described, a multi-object.
Yeah, I was in the middle of that Rhines case that went in bank. But the first part that you're talking about was decided by the panel. Only part of it went in bank. And that was based on the Quixie principle that I just was musing about, as a matter of fact. Oh, Rhines, yeah.
The defendant is punished according to the least severe of the
alternatives. That's right. Here you only had one alternative, and that was cocaine based.
Yes, correct, Judge. And none of the cases that Mr. Groves cites from other circuits goes so far as he's asking this court to do, which is to ignore drug type. I'll talk about Hope in a second, but in the 11th Circuit in Jackson, the court there is comparing Florida cocaine to federal cocaine. Holiday in the 9th Circuit is looking at Montana cocaine versus federal cocaine. Perez, same thing, Iowa state cocaine, federal cocaine. And in the Abdulaziz case from the First Circuit, Massachusetts marijuana compared to federal marijuana. And there was one other, Aguirre.
Could you, you're still on the one of the three arguments. Could you address another of appellant's arguments, which is the one that's based on Campbell? Because I don't see any principled distinction between the statute here and Campbell and Locklear, even though Locklear's unpublished, it's after Campbell and cites it favorably.
Our position is that 841 offenses are controlled substances under the guidelines, notwithstanding that attempted transfer phrase. And this boils down to two things. One, an attempted transfer is not an attempted delivery. It's a completed crime. And to rule otherwise would render the guidelines inconsistent with 994H and with and would render the federal 846 attempt statute surplusage. But secondly, even if Mr. Groves is right and 841 somehow embeds a inchoate attempt, his argument is self-defeating because the definition of delivery to include actual, constructive, or attempted transfer is the same today as it has been forever. And so when Congress enacted 994H and said, go make 841 a predicate career offender crime, at that moment in time, this language, attempted transfer, was there. So if there is this embedded attempt crime, what it means is that Congress has always intended for attempts to be covered. That does not only lose the issue for Mr. Groves, it also undermines the cases that bring us to this point. And we're not here to relitigate Campbell or Nasir and Havis and those line of cases.
You just don't think Campbell applies here.
We don't believe Campbell. We don't believe that 841 that attempted transfer means an attempt. And the Third Circuit.
What does it mean?
Well, here's what I think it means based on what
attempt to transfer does not mean attempt to transfer.
Attempt to transfer is not an attempted delivery. If you look at the three types of transfers in the definition,
Does that make a difference whether, well, go ahead.
An actual transfer is where the giver has physical possession of the drugs and hands them over to the intended recipient. The intended recipient now has physical control. In a constructive transfer, the giver doesn't have physical possession of the drugs. What he has, though, is a means to facilitate the intended recipient's possession of the drugs, physical possession of the drugs. So the common the example we've offered is in the case of a physician writing a prescription. He doesn't have the drugs, but he's giving the recipient the means to obtain physical possession, and then the recipient goes and does that.
What's the point of the word attempt?
An attempted transfer occurs when the giver relinquishes his physical possession by two examples that the Dawson court gave are he mails the drugs. He puts them in the post, but the postal inspector intercepts them before the recipient takes physical possession. Another example from Dawson is if the mid-level dealer drops off at different locations the drugs, and before the street level dealer can pick them up, law enforcement intercepts them. The intended recipient never takes physical possession, but the giver has committed a completed crime. Same is true in the context that we've offered. The example we've offered is when a physician writes a prescription, hands it over.
So attempted transfers are completed crimes, but attempted deliveries are attempted, distribution is not a completed crime.
An attempted distribution occurs when when the drug dealer has taken all of the steps they fixed a price, they fixed a meeting place, they go, they never hand over the drugs, they never even get that far because they're intercepted by law enforcement, or they get wind that the cover is blown and they are going to back out of the crime. They're not going to go forward with the crime. That's an attempted distribution. They have not gone to the point of relinquishing physical custody of either the drugs themselves or the means of facilitating the recipient to have physical possession of the drugs.
Mm-hmm.
That's the distinction. That's it's most explicitly explained in the Dawson case, but it's also explained. That's the Third Circuit, and it's also explained by the Sixth Circuit in Garth, Thomas, Booker, Miller. That line of cases that followed the Habeas case.
Can you say something about the aiding and abetting argument before we're done?
Yes. What I would say about the aiding and abetting argument is that under well-settled principles of aiding and abetting liability, aiding and abetting an 841 offense is the same elements as committing an 841 offense, and it is therefore a categorical match to the guidelines definition. This is a conclusion that is resolved by well-settled principles of the Supreme Court, of this court, and it resolves in favor of a categorical match, which also happens to be consistent with the way the guidelines treat aiding and abetting and the way Congress treats aiding and abetting. We have three bodies of law that treat aiding and abetting, aiders and abettors as principles. It's set out explicitly in 18 United States Code Section 2, that aiders and abettors are to be punished as principles. The guidelines set it out explicitly in 2X 2.1. And it's also implicit in the way that if you compare the way the guidelines treat aiders and abettors, these principles, and the way the guidelines treat attempt crimes and conspiracy crimes, vis-a-vis substantive offenses that those crimes are attached to. I see my time is up. Unless the court has further questions, we would ask that the sentence below be affirmed.
Thank you very much. Appreciate it. Ms. Toma?
Two primary points, Your Honors. First, I think that Quixie is fully consistent with our theory. In that case, as Your Honor described it, there was a general verdict. And so therefore, the baseline B1C 0 to 20 penalty had to be applied because there was no finding of drug type or quantity, if I understood that correctly.
They didn't find the drug type. Of which one it was. There were 3 submitted. And the same thing in Ryan. But the result was that it impacted the penalty. You got the benefit of them,
And I think
of
that
the
that's
lesser
completely
penalty.
consistent
You know,
with
in
what we're
both those
saying.
cases. Pardon?
I think that's fully consistent with what our position here, because we have never disputed that A and B offenses, drug type and quantity, are elements of an A and a B offense. That is undisputed. And when
But the drug type here that he pled guilty to was cocaine based. We know that.
that
You agree with that? He pled guilty
did
to
not
cocaine based,
dispute that
and he
was
was convicted of cocaine based. He wasn't convicted of hemp or anything like that to do with him, or that other thing that we can't pronounce.
And that's consistent with this court's decision in Dolan too, because there's just no constructive amendment. So ultimately,
Constructive amendment on what?
there's no constructive amendment when it ultimately turns out to be proof of a different substance in the same schedule.
That's not a constructive amendment either.
Right, exactly.
It's not. I mean, they do it.
So ultimately, though, what matters here is that the Supreme Court has very clearly said that crack cocaine is not an element of a B1C offense. And that's really all that's needed to resolve this question, irrespective of any conflicting circuit opinions. That's conclusive. Moreover, the concerns that caution us in being very careful about interpreting state statutes, as Justice Gorsuch said just this year in Taylor, just simply aren't present with federal statutes, that we can take this sort of statement as conclusive. I would also point this court to note 13 of Pope. There's a collection of circuit cases there that specifically go through that say that when a statute has a controlled substance, that we shouldn't be interpreting that to find an actual element, a controlled substance element, without clear signals. And there aren't clear signals of that here. In particular, I would highlight Najera Rodriguez versus Barr, which is a Seventh Circuit decision that runs exactly through this kind of analysis with an Illinois statute that is similarly structured with an A offense, a B offense, a C offense. However, I also want to talk about the reasons why this court.
We don't have any state statutes involved here either. All we got is 841.
It's just an example that is in.
Everything is 841 and it's all federal and it's all cocaine based.
The reason why this court cannot follow the Third or the Sixth Circuits is for facially obvious reasons, and it has to do with the circuit splits that are currently set up on actually 2 issues, really. The Third and the Sixth Circuit do not, as we do after Ward, define terms in the guidelines by reference to the Controlled Substance Act. And so this idea that somehow the guidelines must be consistent with how federal statutes operate has been rejected by this court as long ago as in Mills and reaffirmed again in Ward. They've rejected the idea that they need to be consistent and sometimes aren't when there's not evidence that they are following that approach. The Sixth Circuit, for example, in United States versus Havis, at the conclusion of the en banc proceedings in denying the motion for rehearing en banc, Chief Judge Sutton correctly observed that there was a problem the parties hadn't identified at Havis. And that was that the federal statute 841 also included attempted transfers. And he said, quote, "I see no reason to give the guidelines different meaning than that in the Controlled Substance Act. And therefore, in future cases, the parties would need to look at the fact that these are mirrors," right? And very unsurprisingly, that is exactly what happened when the Sixth Circuit considered 841. It has, on one side of the comparison, delivery/distribution, including attempted transfers. And because their terms in the guidelines they interpret by reference to the Controlled Substance Act, all they're doing is comparing the same definition. And of course, there's a match. So that's unsurprising. But this court, of course, can't do that here because Ward says you have to use the ordinary.
Before your time runs out, could you please respond to Ms. Wagner's argument that attempt to distribute and attempt to transfer are somehow materially different?
No, I don't think that's true at all for the reasons in our reply brief, which is that regardless, there are 2 ways you can interpret that term in the statute. You can use the ordinary meaning, or you can use the meaning that comes from how it's been defined in related statutes before. And under either approach, that certainly is not within either one. There is an intent under the common law definition. There is Basically, what all of those things are referring to is a change in possession, and that we don't think there's really any difference. But even if there was, it's still less. Whatever it is less than distribution, and that's enough for us to prevail on that point. But ultimately, we only need to prevail on one.
Is your position that the 841 is indivisible? The government's position is it's divisible.
Are we talking about controlled substances or by?
Well, I'm just, they said 841's visible. You say what? Your brief says it's not, it's indivisible.
I am saying with reference to the whole hope issue, which I think is what your honor is getting at.
No, you can say whatever you want. I'm talking about your brief. They say it's divisible. Ms. Wagner argued it's divisible. I wanted to give you a chance to respond to that. And your brief says it's indivisible.
We would not dispute that other parts of 841 are divisible by drug type and quantity, consistent with what I said earlier.
I mean, the penalties can run from 5 years to life, can't they? Or I don't know, maybe we get death penalty on it. I don't know.
But a B1C, section B1C, the element of a Schedule 1 and Controlled 2 substance just simply goes no further. It stops there. There's nothing else, no other elements to divide it down into, which was exactly the point in Terry that the Supreme Court was making.
Okay. And if it's divisible, we can look at the modified categorical approach. We can go look at all this.
If it's
Other
divisible,
stuff.
yes, the court can use the
That's
modified categorical. If the court has no further questions, we would ask that you vacate and remand for resentencing without the 2K2.
Yeah, I don't know.
Thank you very much. Appreciate your work. And thank you, Ms. Wagner, and compliment both of you on your presentations. And at this point, we would, in the normal course, come down and reach a council table and return to the bench for the next case. But we have dispensed with that process for 3 years now, almost. We will hope to do that next time you're here. So, Madam Clerk, we will reconfigure the courtroom and call the fourth case. Thank you.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Be seated. Ms. Zilstra? The mispronounced, I apologize.
You pronounced it correctly, Your Honor. Thanks.
Pleased to hear from you. Good to have you with us. You can take your mask off.
Good afternoon, Your Honors. May it please the court. My name is Ashton Zylstra, and I have the privilege today to be here to represent the appellant, who's plaintiff Justin Brown. This is a case in which the defendant's employees were permitted, without sanction, to use the N-word in the workplace to make racist, demeaning comments about Black people, to force the sole Black member of the South crew to undertake unsafe tasks and to do dangerous work alone, and to segregate the lone Black member of the crew during morning meetings by purposely giving him his assignments last. And despite this egregious conduct,
After he complained about the comments that he didn't hear directly, to your last point about the assignments, didn't they start making an effort actually to give him the assignments first? But then the problem with that was he wouldn't show up as early as everybody else. So they had to assign other people before him until he showed up.
So, Your Honor, in December of 2016, after that complaint had been raised, there was an instruction by Mr. Copper, who was the head of the DPW at the time, who instructed Mr. Eastland to give Mr. Brown his assignments first. Now, first, that instruction does not resolve this problem. That still segregates Mr. Brown from his white colleagues. It just segregates him in the opposite direction. It still gives him a different treatment from everybody else that has the opportunity to breed resentment in the workplace and to demonstrate a
Well,
distinction.
did he ever complain about getting his assignments first?
Your Honor, I'm not aware of anywhere in the record where he complained about getting them first. However, he did continuously complain about all of this continued course of conduct. And it isn't a requirement that he complain about every single little piece of that continued course for that entire course to be part of a hostile.
In this case, you have a coworker who I think his name was Peach, and he made some reprehensible comments. But I thought the record indicated, you tell me if I'm wrong, that once the plaintiff complained about that and the employer counseled Peach, there was not a repetition of that.
So, Your Honor, there isn't anything in the record to show any further incidents past March 2016, specifically with those comments. There is another incident in which Mr. Peach used the N-word to refer to Mr. Brown in conversation with Mr. Eastland. But the issue here
Was that after Mr. Brown had left employment?
Your Honor, I don't have a specific date for that conversation, but that occurred during Mr. Brown's employment. The conversation specifically occurred because Mr. Brown had done something that Mr. Peach was upset about. And in complaining to Mr. Eastland, Mr. Peach referred to Mr. Brown by using the N-word. But going back to Your Honor's question specifically about whether or not Mr. Peach was canceled, any oral reprimand, if such an oral reprimand did occur, was obviously ineffective in this case because Mr. Peach, person who supposedly was reprimanded, could not even recall whether that occurred and what it related to. So we see that Mr. Peach, in his own deposition, says, I've never been counseled, I've never been disciplined regarding anything I've ever said in the workplace. So regardless of whether or not this happened again, you see that because of that failure of discipline and that failure of proper action, that the institutional.
So, but if the comments aren't repeated and there's no record evidence that it was or Mr. Brown was ever aware of it, help me understand what the injury is going forward.
Of course, Your Honor. So here what we have is a pattern of conduct that is like an institutionalized racism within this employer. So it's not just looking at one act or what one person did. It's looking at everything as a whole. When the employer fails to discipline one employee, what that says to everyone else that works at that place of work is that this conduct is okay. So you see that even though there isn't anything in the record to show that Mr. Peach may or may not have used the N-word after that date, you do see other racist conduct from Mr. Eastland, for example, that continues to grow because of this institutionalized racism. And
Like what? What is the other racist conduct on Mr. Eastland's behalf?
So, Your Honor, Mr. Eastland had 2 times commented specifically that he did not want to be around Black people, which is a racist demeaning comment. And in addition, he also treated Mr. Brown significantly differently from his white colleagues in a very poor manner. For example, he denied Mr. Brown overtime opportunities. He specifically segregated Mr. Brown, as discussed earlier, in giving his assignments. And he assigned Mr. Brown
But the overtime was based on where people lived, who was located closer for safety reasons, as who got the assignment for wherever the issue was. And correct?
That's precisely correct, Your Honor.
Okay, so it wasn't based on his race. And the other giving him assignments last is because he would show up later for the meetings. So he wasn't there in the beginning of the meetings, so he couldn't give him his assignments first.
So that's not correct, Your Honor. When you're looking at the record, you see Mr. Eastland being the only person who's saying that there was this issue because theoretically Mr. Brown was not showing up on time. Theoretically.
No, I think he said he wasn't. He didn't say theoretically, but that's his side of the story. And your side is he was showing up on time.
Yes, but Your Honor, you could also look at the testimony of Mr. Peach, who is also defendant's employee, who said, I saw.
So did Mr. Brown testify that he showed up on time to get his assignments first?
I don't recall if he made that precise statement in the record, Your Honor, but Mr. Peach made a very similar comment.
Yeah, but what did Mr. Brown say? I mean, how did Mr. Brown contradict Eastland on the job assignment part?
Your Honor, I don't recall if he specifically addressed that one concern. However, it is clear in his testimony that in Mr. Brown's point of view, that there was no reason for him to be segregated in that manner, to be pulled apart from his colleagues, nothing that he had done. I don't know if he specifically addressed lateness in particular, but going back to Mr. Peach's testimony, he testified that Mr. Brown was at the meetings, the same as everybody else, and that there was nothing that Mr. Peach had ever witnessed that would justify Mr. Brown being treated differently.
Where is that in the JA?
Hold on just one moment, Your Honor. So that would be on page 1176. That would be part of Mr. Peach's testimony. So speaking specifically to the 4-part test here in determining whether or not there's a hostile work environment, I'd like to first address the second prong here, as that is where the trial court started a line of errors that carried through the analysis in the 3rd prong and the 4th prong. Specifically, the trial court picked out specific pieces of conduct, especially when looking at Mr. Eastland's conduct, to decide that some of that conduct was not race-based, but some of that conduct was. But when you look at the record, not only is there testimony that contradicts the testimony from Mr. Eastland, the self-interested testimony about any non-discriminatory reasons for his actions, but there's also plenty of examples of white colleagues that were not treated the same as Mr. Brown in these instances. And this court very recently just noted that where a plaintiff is treated differently than members of other races, is harassed more than members of other races.
You were saying he was treated differently on the overtime, on the meeting assignments, anything else?
Your Honor, it was denied promotion, denied over.
He wasn't qualified for that promotion
So looking specifically.
because that promotion required a certain level of experience that he did not have, correct? And the person who got the job had that level of experience.
Well, Your Honor, in the record, it shows that there are at least 2 instances where there were employees who were hired directly from an MEO1 position to an MEO3 or higher. And looking specifically at Mr. Brown's background, he did have the experience from
So
his
where's, tell us where that is in the record,
So
to go from 1 to 3.
So, Your Honor, there is a reference to Mr. Eastland, who skipped multiple levels from MEO1 to the crew leader on Joint Appendix 1094, which I believe is in the 4th volume. And on that same page, there's a reference to Norman Downs, who skipped between an MEO1 position and was promoted directly into an MEO3 position, as Mr. Brown was seeking to do here. And when you look at
Here, there was someone who was qualified for the promotion versus Mr. Brown, who was not qualified because he didn't have the requisite experience. Is there an indication that these other people who skipped over the steps, that there was somebody else that there was nobody that was qualified? Because here there was somebody qualified.
Your Honor, to first address whether or not he was qualified, Mr. Kinnaman, who was the one who was promoted, was not qualified. He did not.
I understand he didn't have the commercial driver's license, but he could readily get the commercial driver's license, and he was otherwise qualified by his level of service, correct?
When you look at how central that was to the requirements of the position, for example, Mr. Peach, who'd worked 30.
How central which was, the driver's license or the other thing?
The driver's license. The MEO3 position required operating heavy machinery of a type you couldn't operate without that license. And so Mr. Peach, who'd been working there for 35 years, testified that other than this instance, he had never seen anyone who had been promoted to an MEO3 who didn't already have their CDLA license. And Ms. Bratton, who processed the paperwork, noted that
Did Mr. Brown had his license?
Mr. Brown did have his license, correct, Your Honor. And Mrs. Bratton noted that the promotion paperwork was improperly filled out because it had to specifically state that he didn't meet the qualifications because of the lack of the CDLA license. And I believe I was mentioning the other instances, Your Honor, when we were starting to discuss the denied promotion. There was also the denial of the overtime opportunities. And Your Honor mentioned earlier that it wasn't race-based, it was based on location. But the problem—
Well, that's what they said.
Yes, Your Honor. The problem here is that there's at least 2 instances that Mr. Brown testified to where he was the closest in location, but he wasn't called for the overtime. So those instances where he was the one where policy would dictate—
Is that the time when Mr. Eastland said he called him, but he didn't answer?
Yes, Your Honor. When Mr. Brown complained about that to Mr. North talked to both Mr. Eastland and Mr. Brown. Mr. Brown produced his phone records, which did not show any incoming calls. And Mr. Eastland produced his phone, which did show 2 calls. But most notably, Mr. North was unable to say whether those calls were even in the proper time frame, whether those had anything to do with the overtime at all. So in those instances, and it's especially concerning to see that Mr. Brown was never called for these overtime opportunities, and there had to be instances where he was the closest. And those policies were specifically put in place for a reason, and the only reason for overlooking it to pass it on to his white colleague is if that conduct was based on race.
So why don't we assume that element's met, conduct based on race. Tell us why this is severe and pervasive.
So, Your Honor, looking at the severe and pervasive prong, this is severe and pervasive because it was frequent, it was continuous, and it was a heinous act. We're talking about specifically with the N-word, the worst racial epithet that can be used in the workplace. With the unsafe machinery, we're talking about putting Mr.
So, well, that's an act. I mean, I think that's a different category. How many times and when were the remarks from Mr. Peach?
So Mr. Peach in 2015 made an unknown number of racist comments that Mr. Brown heard about from his colleagues. In March 2016, Mr. Peach again made the same comment, the if any N-word dated my daughter, I would kill him comment.
And was that made to Mr. Brown?
It was made within Mr. Brown's vicinity. So Mr. Brown did not personally hear it at the time, but he was about 10 feet away.
So how's that hearsay considered?
So specifically that hearsay is considered because that was an immediate, it's a statement of a party opponent first, the statement that Mr. Eastland made, he's a defendant in his case, and his coworkers telling him is a present sense impression of what they just heard from Mr.
So that's your theory of admissibility.
Your Honor, that was not fully briefed in our briefings here. So, I
mean, if it's hearsay to be considered, it's inadmissible evidence unless you could come up with an exception to the hearsay, right?
Yes,
You got to have a hearsay rule.
And it is our position that depending on which specific comment we're talking about, it would be a present sense impression.
Yeah,
or an
and that's
excited utterance.
and that's the problem you got with a lot of these statements. I'm going to ask you the same question, but I like to explain not only what statements are, but how they're admissible.
And in addition, they're also admissible to show how this impacted Mr. Brown. To say that it's not necessarily being admitted for the truth of the matter asserted, but to say that Mr. Brown was told these things and this is how he perceived this hostile work environment. And it's important to note that Mr.
So he was told these things by somebody other than the speaker, though, you're saying.
Correct.
The hearsay was repeated to him.
That's correct, Your Honor.
And then you would show his reaction to it. What exception to that hearsay rule is that?
So in that specific instance, in March of 2016, that would be the present sense impression, excited utterance of his coworker turning around. Mr. Brown could see it on his face that something had just been said, and then being told shortly thereafter, this is what I just heard. This was startling to me. This was, unbelievable to me that this was just said. Let me tell you this in the moment.
Now, what you're telling us here now is in the record. Is Mr. Brown said all that?
In the record, yes, Your Honor. It's
Okay.
talking about specifically.
No, but you're quoting your client then on that.
Yes, Your Honor.
All right, his reaction.
Yes, Your Honor.
Okay.
And in addition, Mr. Peach has already admitted to these statements, so those are already in the record as well. Even
for
without-
purposes not to belabor this, but for purposes of this particular element, you have Peach making one or more comments in 2015, a comment in 2016, and then there's nothing from him after that. And then you have two comments from Eastland that, assuming the facts in your favor, that were a year apart. Have you got anything else?
Yes, Your Honor. All of the other conduct. The segregation during the morning meetings happened on a continuous basis that was consistent day after day. There was the.
But in terms of race-based comments, is there anything else besides those?
Not in terms of comments, but in terms of treating Mr. Brown differently because of his race, there's other conduct that's an issue. Your Honors, I believe that I have run out of time. If there are any further questions.
Thank you. You reserved some time, I think.
Thank you very much, Your Honors. We would ask that this court reverse the decision of the trial court. Thank you.
Mr. Levine?
May it please the court, the district court's grant of summary judgment should be affirmed in this case because Mr. Brown simply failed to present evidence of a racially hostile work environment or race discrimination. And I think importantly, the district court did not have to resolve any factual disputes in reaching its conclusion. It didn't make any credibility determination. In fact, the court's primary source of discrediting Mr. Brown's allegations, his charge of discrimination, his complaint itself, his written discovery answers, the court's primary source was his own deposition testimony, where one by one, Mr. Brown essentially debunked each one of his own claims. Mr. Brown started with DPW in January of 2013, the first of the year. As an MEO1, he was cutting grass, maintaining county roads. This is a manual labor position. He had the same supervisor that entire time, Mr. Eastland. And though he alleged in his charge of discrimination that since 2014, he repeatedly complained about all sorts of discriminatory acts. Again, in his deposition, he confirmed that wasn't true, that there were no reports that he made in 2014, that nothing happened in 2014. The entire calendar year, Mr. Eastland didn't say anything that he took as offensive. And the same was true in 2015. Mr. Eastland didn't allegedly make any comments in 2015 or discriminate against him, save this one alleged overtime issue. And it was essentially one instance where there was a snowstorm. Mr. Eastland testified, as Judge Thacker, you pointed out, that either the person closest to the incident or closest to the equipment would be called. And Mr. Brown claimed he hadn't been called and showed his phone records to Mr. North. And as I sort of educated him in his deposition, if you call somebody and they don't answer, the cell towers don't connect, so there wouldn't be anything on your call log anyway. Mr. Eastland, on the other hand, had missed calls that he was able to show Mr. North. So that's the only thing that he raised in 2015. He didn't say, I'm being discriminated against and not given overtime opportunities, which were few and far between as it is. This is not a position where there was consistent overtime and everyone was making a substantial amount of money. Overtime was reserved for major incidents, a downed tree, roads that needed to be cleared. It was unusual. And in fact, under the same supervisor, Mr. Eastland promoted with his supervisor's agreement, Mr. Brown to an MEO2 position in October of 2015. And we discussed it, and though the non-promotion claim was time barred, I think, Judge Thacker, you really hit the nail on the head. There was only one logical person to choose for the position because neither of the two men were completely qualified. Mr. Brown, as you pointed out, did not have the requisite experience, and Mr. Kinnaman, who had 13 years of experience, did not have his Class A CDL. And as Mr. Copper, the African-American head of DPW, who was making these decisions, points out in his deposition, I couldn't magically give Mr. Brown more experience. It made sense to give Mr. Kinnaman the promotion. He had the time and service.
She gave some examples of others who skipped, didn't have requisite experience and skipped from, one level of experience to another. Do you dispute that?
I would say the record's completely undeveloped in that area. It was mentioned in passing in a deposition that people had heard it had happened, but we don't know when, and we don't know what the position descriptions looked like at that time. So for all we know, it could have happened at a time where the county's job description for MEO3 didn't require any years at MEO2. The record is just not developed. They didn't take discovery on that.
So Mr. Brown does not have sufficient evidence on that point.
He has no evidence at all other than some passing remarks without any, context. And so because Mr. Kinnaman had the experience, the county, decided to give him 6 months to get his CDL. And it's sort of interesting. They pointed out in their papers at one point that one of the things that was evidence of discrimination was that Mr. Kinnaman, Mr. Brown had to drive him to go take him to get his CDL training. And, it's really another example of Mr. Brown sort of subjectively believing that everything is discriminatory or based on race. Mr. Kinnaman and Mr. Brown were friends and were colleagues, and this is a small DPW, and there was nothing discriminatory about having Mr. Brown drive him to get his CDL. So in 2014 and 2015, there are no problems. And other than this one instance of overtime that, was really sort of a non-issue, we get to 2016. And in 2016, we have the Peach comment in March. And it's obviously vile and indefensible, and no one's going to say different. Though
I thought Peach was alleged to have made the same comment at some point in 2015, even though Mr. Brown didn't hear it. But I thought there was an allegation that it was said at some point during that year.
That's another area where the record is completely undeveloped. That's something where Mr. Brown said in his deposition, people had been coming to me and saying, look out for Peach, he's saying these racist things. There's no further development or evidence in the record about who was saying it, what was said. There's certainly no admissible evidence that any such thing happened. He wasn't able to develop that testimony any further. There's no record of it ever occurring in 2015.
Well, your colleague there says it's admissible to show his reaction to it, not for the truth of the statement.
Well, he had no reaction to any.
Well, he said it bothered him. He was telling them.
The 2016 comment. So,
Well, that's some of the incidents. I mean, she says there's an evidentiary rule that would let that in.
well, I don't think there's any evidentiary rule that would allow in him saying in 2015, unnamed people were coming to me and just saying racist things. And he didn't testify about having any particular reaction to that. He just says people were coming to me and telling me these things. Nobody was deposed from the crew. Only the supervisors were deposed. So there's nothing in the record from any crew member substantiating that. No affidavits, no depositions, nothing to substantiate that. With respect to the March 2016 comment, though Peach didn't really remember saying it when he was deposed, he didn't deny it. He said, if that's what they said, I must have. And Mr. Copper in his deposition conceded that Peach admitted it at the time. And Mr. Copper, and it's interesting, by the way, when he was asked about his relationship with Mr. Peach in Mr. Brown's deposition, he worked with him very seldom. And he said he really hardly worked with him. This is at 94 of the appendix. And he described him as very cordial. And they would make small talk. Mr. Peach wasn't on that South crew. He was sort of assigned either here nor there, would work with them from time to time, and said he never perceived any hostility from Mr. Peach. So in terms of perceiving his work environment as that Mr. Peach was dangerous or had some disdain for him, Mr. Brown didn't perceive that at all. When this comment was made and it was relayed to Mr. Brown, he said it made him uncomfortable. And I think it's interesting because it underscores how this type of thing wasn't a pervasive thing in the work environment. But the employee that heard it immediately goes to Mr. Brown and says, you're not going to believe what I just heard. I think you should know this, as opposed to just, well, I'm not going to tell him. This is just how we talk. I think it's indicative of the opposite of what Mr. Brown alleges, that this was a widespread practice, people bandying about these epithets and slurs. This Caucasian employee was disturbed by hearing it and immediately reported it to Mr. Brown. Mr. Brown goes to Mr. North, the road superintendent. Mr. North immediately reports it to Mr. Copper, though their briefs essentially contend nothing was done. What Mr. Copper did was what he felt was appropriate, which was he gave a verbal counseling to Mr. Peach and said, this won't be tolerated at DPW. And as various members of the panel have pointed out, there's nothing in the record that indicated it was ever repeated. The other instance that was referenced came out in Mr. Eastland's deposition and was the first time Mr. Brown even knew that it happened. He learned about it for the first time after hearing it in Mr. Eastland's deposition. And Mr. Eastland described the only instance he was aware of where Mr. Peach came into an office, was angry about something and used the N-word in reference to Mr. Brown. And he wasn't having a conversation with Mr. Eastland where he knew this would be acceptable to use this language. He came into the office yelling, and Mr. Eastland happened to be standing there and was shocked by what he heard. So there's no evidence in the record that it was repeated. And I think the district court accurately pointed out that as a matter of law, the discipline was sufficient because there's nothing to indicate it happened again. As to the September 29th Eastland comment, and it's interesting, all throughout their papers and the complaints and the discovery answers, it's been one very specific day.
You know, what year are we talking about now?
2016, September 29th of 2016, when Mr. Brown has alleged that Mr. Eastland made the comment, I don't feel like being around black people. Set aside Mr. Eastland's categorical denial of that. That appears in the record as double hearsay. Though he initially contended that he heard it, he conceded at deposition that another employee by the name of Dean Davidson had relayed that to him. Mr. Davidson was never deposed. No affidavit was obtained from Mr. Davidson, and Mr. Davidson is now deceased. So there's no admissible evidence in the record that that comment was ever made.
Unless there's some theory of admissibility under the hearsay rule.
Unless there is, and at the summary judgment stage, nothing was raised by Mr. Brown suggesting the court could consider it under some exception to the hearsay rule. They simply said, we say this happened. And when in our motion, we said, well, it's double hearsay. You don't have anything from Mr. Davidson to substantiate it. There was no answer for that. As to the second comment, this was a point in Mr. Brown's deposition where after he realized he couldn't substantiate the fact that the September 29th statement was made by Mr. Eastland, he just sort of did one of these, well, it happened another time. And tell us when. No information about that. No information about what year Mr. Eastland allegedly made this comment. They were working together for 5 years, from 2014 through 2018, when Mr. Eastland left for medical reasons. So there's nothing in the record if we say, well, there's a comment he actually heard. He heard Mr. Eastland say this. We have no information about when that happened or what the comment was. He had guessed that, he heard it while he was walking by Mr. Peake, but there's no development in the record. And so essentially all he has that he can attribute to Mr. Eastland over a 5-year period of time. It began in January of 2014, and though Mr. Brown left in 2019, Mr. Eastland left before that, in October of 2018 because of an injury. That's all he has is an alleged statement by Eastland in September of 2016, that's double hearsay, and this alleged instance of hearing Eastland say it himself with no factual development whatsoever in the record. So in December 2016, Mr. Brown finally goes to Human Resources and says that he's given his assignments last. And they've, I think, mischaracterized this as being segregated. It wasn't segregated. The way the assignments are given is they muster in a break room, and there's only 8 or 9 employees. It varies from time to time. And as Mr. Eastland sees people, he gives out the assignment. And what's interesting is these are manual labor assignments. It's not like they're going out to earn commission and you want to be the first one to get your assignment. I would almost suggest that if he was singled out and given his assignment first, that might be a punishment. If they said to him, Mr. Brown, go cut grass, we're all going to sit and have a cup of coffee for another hour. That isn't what happened. The assignments are given out for these employees as they come in. And when Mr. Brown complained, his own characterization of his complaint was communication issues. And that's at 157 in the appendix. That's what he told HR the problem is, that he has communication issues with Mr. Eastland. He doesn't think Mr. Eastland likes him. And that, quite frankly, he doesn't like Mr. Eastland either. He confirmed that at this December meeting, he made no report about being asked to do any type of less desirable or dangerous job. He didn't say, well, he gives me my assignment last, and I have to do this horrible, I have to dig ditches, and all my colleagues just have to do some light manual labor. They have a much better time. He didn't make any type of complaint like that. He didn't report any overtime issues in December of 2016. He didn't report any alleged racist comments by Mr. Eastland, and he didn't even bring up the Peach comment in 2016. And in short, he didn't report discrimination. He reported a communication issue and essentially a personality conflict. And as Judge Thacker pointed out, the county attempted to resolve this by having them engage in these weekly meetings where Mr. Eastland was supposed to give him his assignments first. But as Mr. Eastland explained, it really didn't work out long term. It didn't make sense for me to stand there with 8 people waiting to get their assignment, and Mr. Brown's out in the hall on his phone, and so they're all waiting. So he would give the assignments as they come. But it just doesn't plausibly evidence racial discrimination or a hostile work environment. They move on to the sort of miscellaneous grievances that occurred in 2017, as I described it. No alleged racist remarks of any kind in 2017. But when we talk about these equipment issues and the district court walked through these carefully in its opinion, Mr. Brown conceded he was never instructed to do any of the things that he alleged he had to do by himself. He was asked, well, you alleged you had to take the grater blades off by yourself, a dangerous task. Is that what Mr. Eastland told you to do? Well, no, he just told me to take the grater blades off. Did somebody end up helping you? Yes, in every single instance. He was assisted by somebody else, called Mr. Eastland on the radio at one point when Mr. Eastland said he would come. Mr. Eastland said he was on his way. He didn't wait for him. Somebody else helped him. So all of these equipment issues are really just a red herring because Mr. Brown himself conceded in his own deposition that he wasn't instructed to do anything dangerous by himself. The other thing they alleged, and they have sort of walked back from it, it appears in the charge of discrimination, is Mr. Brown says he was disciplined differently than his Caucasian colleagues, that he was subjected to write-ups. And we went through this with Mr. Brown in his deposition. And with the exception of one instance where the director of DPW, Mr. Copper, wrote him up for running over a mattress, Mr. Brown discovered, I think in his deposition when he was presented with the documents, that in the 3 instances that he was written up in 2017 and was with a Caucasian colleague, his colleague got the identical discipline. The write-up is literally identical verbatim. The names are different. That's the only thing. And so far from being disciplined differently, he was disciplined identically. And it went no further than a write-up. There was no loss of benefits or salary or anything along those lines. So the district court walked through each of these categories of evidence very carefully and concluded that none were simply borne out by the record. These weren't racially motivated instances. And though Brown asked the court to ascribe everything that happened to him, every aspect of his job, to race, the court accurately realized this was simply a mischaracterization and an exaggeration, and that he was relying essentially on subjective perspective. So within the framework of Title VII, this is nothing like any of the cases this court has seen recently where there were tribal issues. Struthers in 2018, where from day one, the employee was singled out for harassment by her supervisor and fired before
You sort of make it sound like the judge made findings of fact.
I don't think that,
You said the judge did this, and the judge rejected this, and the judge did that. The judge was obliged in this setting to take the view most favorable to the plaintiff.
correct. And the only thing the district court did was look at Mr. Brown's testimony instead of his allegations, because that was the conflict. The dispute wasn't between Mr. Brown and the county witnesses. The dispute was essentially between his allegations and his testimony. And the district court didn't make any factual findings and didn't make any credibility determinations. The district court looked primarily at Mr. Brown's own testimony.
I'm just referring to the way you were arguing it. It sounded to me like you were arguing that about a judge who had a bench trial. And he made findings about the plaintiff's testimony and this and that.
It may
But he didn't do that, did he? He had to take
I
the
am saying,
view, he had to accept the version most favorable to the plaintiff.
correct. He accepted the version that was essentially Mr. Brown's version from his own deposition testimony. He didn't have to make any specific findings. He was pointing to his own testimony. So this is nothing like Spriggs, where there were incessant racial slurs, epithets, and insults by a supervisor, habitually called the N-word, called things like monkey, just abhorrent things that cannot be tolerated in the workplace. None of those things happened here. Frequent and highly repugnant insults. Boyer Liberto in 2015, a cocktail waitress who was twice called a porch monkey by her manager, firing, another abhorrent instance. But more akin to Perkins. An instance where, frankly, not only is there not sufficient evidence that the workplace was objectively hostile, but there were really no subjective evidence either. I mean, Mr. Brown never testified that he really subjectively viewed his workplace as hostile, that any one thing altered how he did things or how he perceived things. He described generally good relationships with coworkers, including Mr. Peach, who made this horrendous comment in 2016 saying, no, we got along fine. He didn't seem hostile to me. We made small talk. I didn't have any issue with him. An employee who was promoted within a year. So the district court saw this case for exactly what it is, as Mr. Brown himself described it. Mr. Eastland didn't care for one another. And this is the classic supervisor-subordinate personality. And at the summary judgment stage, which is where this was resolved, it's simply not enough to tell, you have to show. Nor is it sufficient to say, well, I didn't get this evidence in the record at the summary judgment stage, but my luck will improve at trial. Can't do that either. They had a full and fair opportunity to develop the record. And on this record, the district court should affirm, this court should affirm the district court's entry of summary judgment for the appellees. Thank you. Is there any questions?
Thank you very much, sir. Ms. Zylstra?
Yes, Your Honor. So first, I'd just like to address.
You can take your mask off.
Sorry, Your Honor. So the first point I'd just like to address is that it's interesting how counsel tried to downplay what it really meant to have Mr. Brown singled out from his colleagues to be given his assignments last. And that's specifically because two of defendant's own employees testified specifically that that conduct could lead to a hostile work environment. Mr. Copper testified that it could be a hostile environment for a Black person to always be assigned work last. And Ms. Bratton, who is an HR professional trained specifically on the legal definition of a hostile work environment, conceded that being assigned work last could potentially lead to a hostile work environment. So it's interesting that now they try to downplay it and say, no, that isn't bad at all. You know, they were all in the same room. No one would have even known.
How's that admissible evidence?
Your Honor, it's
Testifying about legal conclusion.
Your Honor, it's demonstrative of the objective element
Are
of.
they expert witnesses of some kind?
No, Your Honor, it goes to whether or not that objective test is met in the severe and pervasive test. Because what we have here are two reasonable people putting themselves in the place of Mr. Brown, concluding that a hostile work environment is here. And that is the exact question that the court needs to look to when finding that objective test of whether or not a reasonable juror could find in Mr. Brown's place that there was a hostile work environment here. So both of these comments go directly to answering that question. And as Your Honor pointed out earlier, there are findings of fact that the judge has made down at the trial court level. And specifically, counsel has asked you to make continued credibility determinations. When he says, well, Mr. Brown testified that he heard this in 2017, but you shouldn't believe that. You shouldn't believe what he says. Instead, you should believe what Mr. Eastland says. And that is precisely the type of credibility determination that is not right at summary judgment stage. That is a determination that should be determined by the fact finder at trial, whether or not they believe Mr. Brown when he stands up and says, in 2017, I was walking through the yard and I personally heard Mr. Eastman say, I do not want to be around Black people. Now, looking back to the assigned dangerous task issue. Now, counsel would minimize this issue to just say, well, he wasn't specifically told to do the two-person task on his own. What Mr. Brown was instructed to do, as counsel noted, was remove the grater blade. What Mr. Eastland, his supervisor, did not do was assign assistance. So even if he never said overtly, do it yourself on your own, this unsafe task that everyone has agreed is simply not safe for one person to do alone, what other option did Mr. Brown have?
What, wasn't there a mechanic that advised that it was safe? Breeding was the mechanic's last name?
I believe Your Honor is referring to the instance where he was driving the grader. So
Oh, I thought you were talking about the grader.
Oh, no, Your Honor.
All right, so
The grader blade.
oh, is that the time when Mr. Eastland said he was going to help him, but Mr. Brown didn't want to wait for him to come and help him, so he did it on his own?
That was the time when Mr. Eastland did not assign plaintiff any help at all. From Mr. Plaintiff's deposition testimony, he did not have any help, and he was ultimately helped just by a colleague who serendipitously was passing through the yard at that time. But to Your Honor's question about the specifically driving the unsafe grader, this is again another point that is only testified to by Mr. Eastland. When Mr. Brown saw these unsafe things on his grader, the bulging tires, the punctures, it happened 3 different times in the record, Mr. Eastland claims that he went to Mr. Breeding and he claims that Mr. Breeding told him that it was okay. But if that were true, why would it be that Mr. Copper minutes later would call Mr. Brown and say, come back, this isn't safe? If a mechanic had checked it, there simply would be no reason for that. And in one instance, the tire even needed to be changed. And Your Honors, my time is up, so if there are no further questions.
We appreciate it very much. Thank you. Appreciate the arguments of both counsel, and if we could do so, we'd come down and greet you and shake your hands in the well of the court, as our court does as a general proposition. We're not doing that right now. So all the best to you, and we'll take your case under advisement. Madam Clerk, we can adjourn court until tomorrow morning.
Honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.